extension of interim order, my lord.
When is the interim order expiring?
My lord, it is expiring on 30th June, the first day of the next circuit. My lord, the interim order will
I
expire.
will not, I do not have the habit of extending the order without hearing.
My lord, the interim
What
order
prevented you from mentioning it priorly? We are on the,
on 16th, my lord. This is today 17th. My lord, only 3 days are left for this circuit, my lord.
that is what I am saying exactly. What prevented you from mentioning in the first week? You are coming in the second week after
My lord,
expiring.
it can be,
Sorry,
my lord,
I don't have this practice. This is a very bad practice that you obtain an interim order and you will not allow the other side to even object to that. Drop of a hat without applying my mind, I will be extending the interim order. Sorry,
actually in this matter as led by Mr. Shakhosh Senior Advocate.
whoever is leading you, the name does not matter. The name does not matter. Why will you not grant the other side an reasonable opportunity
I have
to
served the
object?
notice, I'll serve and come back again, my lord. My lord, I'll serve and come back, my lord, during the course of this. Kindly will it be.
I will not do. Firstly, you are asking for extension of interim order without a notice.
My lord, I'll serve during the course of.
I go in my list. I have mentioned it. No mentioning without notice. If you cannot follow it, it is not my problem.
My lord, with your kind permission, I'd like to mention, yesterday we had mentioned regarding the upgradation of the list, my lord. And then the
Which
opposite
matter? Which matter?
item number 51, CO 183.
See,
my lord.
you
Yes,
mentioned
sir.
you mentioned it that because Mr. If I correctly remember,
Bilwadal Bhattacharya.
Bilwadal Bhattacharya had come and mentioned it on the first day.
Yes, my lord.
He said that there is a likelihood of settlement.
Yes, my lord.
Yesterday, I was
Yes,
given,
my lord.
yesterday I was given an impression that the parties have settled.
Yes,
What
my
is?
so
See, if I place the matter and I find that there is no settlement,
the settlement,
then I will put both of you to task.
my lord, the settlement is completed. The other side has been served notice, and this is the copy of.
Settlement is complete.
Yes, my lord.
Now, under the appellate side rules, you have to make a joint petition. Are you aware of it?
Yes, my lord. For that, we
Yeah,
are
in the original side,
we're praying for the.
in the original side, you can file a terms of settlement duly stamped and punched. But in appellate side, you have to make an application, joint affidavit that we have settled. These are the terms. The terms will be part of that petition.
My lord.
So that the order can be passed, making the terms as part of it.
My lord.
Otherwise, again, there will be error, mistake in typing out, and that will lead to problem.
My lord. My lord, as I'm being led by Senior Counsel Minister Bilwadal Bhattacharya, under his direction, kindly list it tomorrow in the, my lord. So,
See,
my request here.
there is no question of not listing it. Where is the application?
My lord, the application tomorrow we're gonna produce it in the court. And then the opposite parties have also been intimated and copies have been served, my lord.
6 years have passed in the circuit bench. If you are not aware of the procedure, I cannot help you out. Please make submission after applying your mind. Tomorrow, what will you place? You say that tomorrow I will place the. If you do not file the application tomorrow, can it appear in the list tomorrow? Tell me. You file the application, give the number, or at least you file it in a one-page application with the terms
My lord.
and the joint affidavit of the parties. You file, you give the number, I will place it in the list.
Grateful, grateful.
But I am appealing for the respondent.
Yes, please do whatever you have heard what I have said. Please
Yes,
comply with
my lord. Yes, my lord. Yes, I understood.
Prashant, may I mention a matter for inclusion in the list? It's a civil motion matter, regarding the it's been transfer of a matrimonial suit. Lordship, upon service to the opposite party,
When did you file it?
Lordships are filed on March 2025.
Now, if it is in March 2020, it had appeared before any circuit bench.
Lordship,
You obtained an order of adjournment.
Lordship.
And now I am on the 7th day of the circuit, out of the 10th day. You are coming and mentioning, I cannot, whatever in the list, because I am sitting for 1.5 hours, I cannot take the entire list. And you are saying inclusion.
Lordship, on the last occasion, your Lordship was pleased to direct me to service upon the opposite party.
Very
I have
well,
served
give
and it
the,
is effected, Lordship.
you give the slip, you have served.
Lordship, it's effected, Lordship. Kindly take the.
I don't assure you any path because the time period is very little, but in the number I will look into.
Lordship, great. Great.
স্টে যে মামলা আছে সেগুলো করবে না, নতুন মামলা ওই 24-এ একটা অর্ডার দিয়েছি ট্রান্সফারে, সেই জন্য এনকারেজ।
Item number 1.
Please, my lords. I beg to appear, my lords, for the OP3. I'm deeply grateful for your lordship's indulgence. My lords, we filed a application for vacating the interim order pursuant to your lordship's liberty. My lords, I can't hear my learned friend.
Mr. Chaudhary is about to reach, my lord, in 5 minutes past.
My lords, let me start. My lords, I have a list of dates. Let me place that, my lords. Mr. Chaudhary can join in the meantime, my lords. I am only giving a background of the facts.
I made it very clear yesterday. If he is not there, I cannot help you out.
Just 5 minutes short past.
My lords, let me place a list of dates, my lords. I have a list of dates.
Start.
Yes, my lords, your lordship had indicated that a list of dates will be helpful. So we have prepared a short 1.5 page. My lords, we'll just pass it on to you if your lordship can have that. Yes, my lords have my list of dates. So, my lords, this started in.
Hey, give the other side a copy. Give the other side a copy.
So, my lords, this started in November 2010 when Sabita Srivastava, who's the borrower, borrowed about 9 crore rupees by creating an equitable mortgage.
Sir, the right of audience is with the bank because you were not in the picture
Please,
at
my
that
lords.
point of time. Why should I
Please.
hear you on this aspect?
My lords,
I will hear the bank.
Yes, my lord,
No.
I am there.
Your lordship had last time, if I just can say, my lords,
See, your right has come after you purchase, you are the successful purchaser in the auction.
Please, my
Prior to
lords.
that, you cannot have any direct knowledge about what had happened. So why should I hear you on that aspect?
No, my lords, I am only.
I will definitely hear you on the post-auction issues.
Yes,
But-
my lords.
Yes, please
My lord-
allow the bank.
My
My
lords, just
lord.
one sentence, if my lords, I can say. My lords,
No, complete wastage of time. Please wait for
please,
your
my lords.
My lord, as per my list of dates that has been supplied by my junior before my lord, the equitable mortgage was created on 19/11/2010.
At the first question, at the time when you the equitable mortgage was created,
Yes, my lord.
was the land a agricultural land?
No, my lord. That has been totally
How do-
calculated on merit. Merited-
How do I get that?
Yes, my
What
lord.
are the-
My
what are
lord,
the-
this point has been already been settled before the DRT on merit, and in the wide order of the DRT, the issue number 1 and 2, it has been taken up, and the court has been satisfied regarding that.
See, I am not even given the order of the DRT. You are making submissions, but I need to look into the order of DRT.
My lords, that application is a part of the record.
Your in their application, but when you were the party, you will making a submission, you will not rely upon it. Then show
No.
us, show me.
I have a comprehensive list of dates. May I hand over?
Yes, Mr. Chaudhary. 3 list of dates are being handed over to me.
Oh, my lord.
So,
It will be same, my lord. It cannot be changed anything.
My lord, the app, that I have been relied upon the page number 28 of their petition, my lord. Of the petitioner's petitions, page number, annexure page number 28, my lord.
yes,
Yes, my lord. The issues has been taken up.
28.
Yes, my lord.
28.
My lord, they have marked as 28 only, my lord. At the last annexure, my lord. The copy that has been served.
See,
Yes, my lord.
you tell me there is a revisional application and there is also an application which is CAN 1. You are referring to which application? The revisional application or the CAN application?
If I can just assist your lordship, this is page 35 of the supplementary affidavit that petitioner filed. That's where the order is. Page 35.
Very well.
Because this was filed on 11th.
Yes. এই সাপ্লিমেন্টারি এফিডেভিটটা কোথায় গেল? হ্যাঁ, এগুলো খুলে ভাই এত বড় হ্যান্ডেল করা যাচ্ছে, সে খুলে যাবে সব।
That fatty one.
রিভিশনাল অ্যাপ্লিকেশনটা কোনটা?
My lord, the supplementary.
Yes, page 35.
Yes, my lord. And the ordering portion is at page number 37, point number 9.
Yes.
Page number 37, my lord, point number 9.
Yes.
Yes, my lord. Sub point 1. Whether the land, my lord, may I quote, my lord? Whether the land in question is an agricultural land and surfacing measures cannot be initiated over the said property in view of section 31(1) of Surface Act and whether the applicant or auction purchaser is in possession of the property. Point number 1 is the section 31 of 1 of Surface Act.
31 I. 31
I. My lord, pardon me.
Well, can you read paragraph 10? Not necessarily anything. Okay.
See, whatever the Supreme Court judgment is there, it is on analysis of facts of that case. But the fact is that the DRT ought to have sought for a report from the BLRO. What was the nature of the land in 2010 when the security interest is created? If we allow that by consent, the statutory embargo can be whittled down, then the whole object of the act will get frustrated. Because see, the concept of nationalized banks, commercial banks, in respect of agricultural land, why it was done? It was done because there in our country, the NABARD controlled banks, that is agricultural banks, are there for granting agricultural loan. Now today I have a property which is agricultural land. Now the bank, I am offering that for security, and the bank, without taking note of the embargo, obtains it. Then what will be the situation?
My lord, in this point, my lord, let me clarify regarding the point that who can raise the whether the land is an agricultural land or not. The Surface Act totally lies between the borrower and the financer.
The borrower,
The person who has come before my
see,
law.
I will give you the Supreme Court judgments.
Yes, my lord.
In case of subsequent purchaser, in case of suit for specific performance,
Yes, my lord.
if there is a subsequent purchase, the Supreme Court has categorically said that the right which is affected is that of the purchaser, because in this case the borrower who had sold the property in 2007, he has washed off 17, he has washed off his hand. He has got the money, he has washed off his hand. Why will he come and defend?
No, my lord, in the time of the mortgage, the intention of the mortgage was to create interest in favor of the bank. It was not an agricultural land, my lord, which has been, my lord, that has been also been recorded in the order also, because at the DRT, the borrower has stated that it is not an agricultural land. Now, my lord, the person who has come before your honor with a deed which has been manufactured and dealt with by the power of attorney holder of the so-called the owner, who is the opposite party number 2. But we as a financer, we have mortgaged this property. They have said that this property is not used on agricultural land, and at the time of the mortgage, it was not used on agricultural land, which has been dealt with the Supreme Court judgment in the Blue Coastal as well as in the Sridhar versus Indian Bank in the case. And my lord, in this case also, the DRT has totally calculatively seen whether the land which has been asked for rebate has been.
See, the bank has relied upon certain documents.
Yes, my lord.
And the aggrieved person, that is the purchaser, petitioner, has relied upon certain documents. So you have asserted your right. The petitioner had asserted it.
But when the mortgage has been created, my lord, whether their right is there at all. When we are the mortgager, when the mortgage has been done in favor of the financial bank, assistance has been taken. If subsequent sale is happening, whether that is at all stand in the law.
The difficulty is that you are not appreciating the fact, if there is a statutory embargo, as a nationalized bank, you are functioning under the RBI, can you do so? See, record of right is not a title document. It is settled law.
Yes,
but record of right has an importance, because what is the nature of the nature and character? Neither the borrower can say, neither the bank can say. It is for the BLRO to say what was in his records. If the BLRO report has not
My
been.
lord, my lord, in this case also it is stated in the judgment and it is quoted in the judgment also. My lord, let me just make a
The
submission, two line, my lord.
judgment will come later. Judgment is based on a
On-
facts of a particular case.
Yes, my lord, even if the petitioner, here comes the second point, my lord, the who is going to have the relief as an agricultural land? The Speech First Construction Private Limited Company is itself a construction company. In the MOA and AOA, it is written it's a construction company. Then
That
how
is-
they can go for a land which is
No,
meant for the
no.
agricultural land, my lord?
See,
The intention is
see,
totally clear.
That is a subsequent question. That is a subsequent question.
Mortgage period.
If the bank has done anything contrary to the statute, then it does not sound good in the mouth of the bank that who can ask for this, who can. Now tell me what wrong has the auction purchaser committed? You have put up the property for sale. The borrower had washed his hand in 2017. Under the Supreme Court judgment 2024 volume 1 SCC, that borrower's right exists till the property is put onto auction. Now, see, for your action, somebody has been duped. Let us say that the petitioner has purchased the property for valuable consideration. Now, under the Transfer of Property Act, a bona fide purchaser for value without notice is protected. Now, the issue which is most germane, whether the petitioner is a bona fide purchaser.
Yes, my lord.
Now, who has decided it? Now, you are mixing up because of the difficulty of the bank.
Yes, my lord.
You are difficulty of the bank. You are playing in a home field or home wicket. You are aware of everything, but so no one is taking you to task that you commit mistake. You escape scot free. Now, when you created the security, did you make due diligence? See, many issues are coming because if it is a equitable mortgage, the
Yes, my lord.
original title deed must have been with you.
Yes, it is with us only.
Let me say, finish.
Yes, my lord.
Now, how without the original title deed being given to the purchaser, that is petitioner, how could he go for the sale transaction?
Yes, my lord.
All
They are
see,
not in the possession of the original deed also, my lord.
Now the question is, see, you can distinguish the cause of action into two segments. One, whether the bank has committed any illegality in giving a financial accommodation by taking an agricultural land for security.
Yes, my lord. Okay.
Now, for this reason, there may be, I am not sure because I am not the fact-finding court.
Yes,
I
my lord.
entertained the petition only because for the time being, when the DR80 was not available, because admittedly an appeal was filed, now a person cannot be left remediless.
No, my lord. Here is the second point comes, my lord.
Now-
DRT is
now-
functional. DRT is functional, and it is DRT chairperson is sitting, and for that sake, my lord, they have not made even an interim application before the DRT against the DM order. They have straightway before filing the interim application, they have come forward to you, my lord.
Now the issue will be the auction purchaser had cited a judgment 2023 1 SCC.
Yes, my lord.
Paragraph 35, it says, what does it say? That the ACJM does not decide any right between the borrower and the bank.
Yes, ma'am.
But if you look into the judgment of Harshvardhan 2014, which was diluted in 2016, and that diluted portion was overruled in 2019. If you look into those judgments, you will find an elaborate discussion has been made in respect of tenant and lessee who are in possession. Now, in that judgment, you will find the Transfer of Property Act even does not create an embargo on the mortgager in creating a lease, but that has to be for a period of 3 years, and the lessee has the right of audience before the ACJ or
Miloj,
the
may I-
magistrate.
Miloj, may I
Now-
come on that?
I will give you an opportunity.
Just
Let-
on that point, Miloj, if
Let me explain. I may not be correct. Your interpretation may be different. So it was said that there can be two types of lease created. One prior to the mortgage and another after the mortgage has been created. Now, in respect of prior mortgage, then the rights in respect of the lessee has to be governed by section 111 of the Transfer of Property Act, because there one notice has to be issued under section 111G for forfeiture of lease, and then you can proceed. For post mortgage lease, it has to be decided on the basis of section 65 capital A of the Transfer of Property Act. And I can tell you the transfer of property probably section 58 or 58, it does not create an embargo.
please,
It does
Miloj.
not create an embargo. But you cannot give a long time lease. It can be only limited
Month on
to 3 years, maximum period of 3 years. So if somebody, what was the object? That somebody has been in possession, let us say today, illegally or by some measure, the petitioner has stepped into possession of the property in question in 2017. If that be so, then if his title deed is proved to be an untenable document, then what will be his status? He will be a trespasser. Now, if he is a trespasser, you will find in the judgment tenant and sufferance, they are not protected. But at the same time, Supreme Court, as far back as in 1968,
Due process.
and thereafter in 89 also reiterated and subsequently has said that even a trespasser cannot be evicted without due process of law.
Yes.
Now, what is the due process of law?
Go to court.
You can say section 14 is a measure of due process of law. Then if that be so, then you have to give him a chance to represent him.
Miloj, I beg to disagree on that. All your lordship has said is absolutely right. And let me just cite two judgments on the point. Because, Miloj, today what are we considering? Your lordship is considering whether the petitioner, one, was required to be made party in the ACJM proceedings. Number two, whether he had a right of audience. This is the question that my lord is exactly considering. All other issues your lordship has already indicated.
See,
It's a matter of fact.
Honestly speaking, I am also not considering that,
Please,
because
Miloj.
right, if any, is under section 70.
Please,
Now,
Miloj.
Yes, ma'am.
I am not going into the merits of the case. I refrained. Last time also you tried to take me into the merits of the case. I refrained. I said, since the DRAT is not functional and sir, your information is absolutely incorrect because on the day when I had passed the order, the DRT was not.
No,
No,
my lord,
Milord, I'm
I
sorry.
correct
That's
myself.
an incorrect. One second,
From
sir.
Monday
That's
it
an
is in functional.
Milord,
From Monday.
Milord, let me answer that. And Milord, I have a
Because
lot to say on that.
The DRAT was supposed to sit from Friday. I do not know whether
No,
on
Milord,
No, Friday has, they have,
I have a-
chairperson has not
I have
taken
a
the
lot
seat, my
to
lord.
say.
From Monday, they
From
have taken the
Monday
seat.
to Friday. From Monday to Friday, DRT did not. Chairperson was not
Milord,
available.
From
Milord,
this
I have
Monday,
a-
chairperson has taken the chair, my lord, and the matter is going on. And my lord, not only that, the main factor is that
But may I hand over 30?
whether they have made any application of interim application, my lord,
now
before the
they-
DRT regarding this.
now
section.
there is also a issue, I tell you, because I don't keep anything under my sleeves. The intimation which I have received that the DRAT is going to proceed to Hyderabad for holding a camp.
Milords, may I say this? Let the petitioner, Milords, and Milords, I am saying this very responsibly as an officer of the court, not for my client. Milords, Mr. Chaudhary made a submission that the DRT is not functioning for a week, 10 days. Let him show one pleading
Yes,
in his
I'm showing.
application or a supplementary affidavit. There is nothing except to say, Milords, Milords, one paragraph where he says DRT was not sitting on 22nd of May and that DRAT is not sitting on 10th of June. Except for those two dates, there is not even a single sentence in his petition, Milords.
Before signing the order, I had myself inquired that
No, Milord, that may be the case.
whether the statement of the petitioner that the DRT is on leave for this week is correct or not. Because I did not sign it instantly. I have taken note. I am telling you. I was told that the DRAT from the registry that the chairperson is scheduled to sit on Friday, but it may be from Monday.
Not
Very
Friday.
well. Milords, all I am saying today is, Milords, when the petitioner.
See, the issue today is, to be very candid, I am minded in sending the petitioner before the DRT under section 17 so that he can avail his remedies over there as held in by the Supreme Court. I will I will try to maintain the status quo of the property for a limited period to allow him to go before the DRT within, say, 10 days from now. And the order, this interim order will be there for 21 days.
Yes.
Then it is for
It is my
because
fate.
I am not the fact-finding court. I am a revisional court.
Milords, I bow down.
I cannot go.
Milords, that's the most fair and reasonable, Milords, what has fallen from your lordship. There are two things, Milords. One, after your lordship's order, which restrained me, the auction purchaser, and the bank, they have tried to dispossess me. So if your lordship were to protect my possession today, and in the meantime they are given an opportunity, I have no problem.
I see. I can give you the judgment also, in which case police assistance can be given. I will ask the local police station to look into that. The order passed by this court is not flouted.
No, Milords, what has happened is your lordship in the
Already
order.
I made a prayer to the concerned police station for
Only
deployment of police at the cost of the petitioner, Milord. This is
Milords,
the
petitioner is
already
not
I
in
have addressed.
possession today.
My
That's the
lord,
problem.
my
Milords,
lord,
what
my
happened
lord, the
is-
for a
petitioner
today.
is
Is a 12
just,
June
my lord,
letter.
let me
When-
just hear me regarding the bank. My
Milords, may I
lord,
say this? Milords, may I say
I
this?
have the Panchnama where the officer of the district magistrate court has handed over the possession to us, and we have handed the possession to them. Then
Yes.
how come
18
the
bigas.
petitioner is in possession of any portion of the land?
Yes, 18 bigas.
See, that is a question of fact. Can I
No,
go into this?
No, Milords. Milords,
Can
but
I
kindly
go?
see what is happening.
Ah.
Milords, kindly see
No,
what
no,
is happening.
I appreciate that you are apprehending a mischief and they are trying to take advantage of this order.
No, my lord, they are taking the advantage, my lord.
Just a minute, just a minute. To barge into the property according to you to dispossess it.
Please,
Now
Milords.
today, see, the issue is such, actually, who are on crossfire,
Please.
the auction purchaser and the petitioner. The original borrower, he has washed off his hand.
He's not
The
appearing
bank-
before your lordship also.
Yes, the bank after
He's stuck in between.
after selling the property has also washed off his hand because it has realized its debt. Now you and the petitioner, those who are otherwise not connected with the substantive transaction, are at loggerheads.
Please, my lords.
Now, this is a situation where I cannot at this stage, because see, ultimately you are deriving right from the bank. Now, if the auction sale, I cannot set aside the auction sale. If the auction sale is void, then the bank has to undo the thing. It has to refund you the consideration money with interest. Now, for the petitioner, they are stuck in between because their cause of action is twofold, if I have correctly understood. Because whether the borrower has perpetrated fraud on them has to be gone into. This is a case inter se between the petitioner and the borrower. Now that cannot be a subject matter before
Of
the
DRT.
for the DRT.
Yes, civil
Now,
court.
civil court. Now, because of the embargo or the stipulation in section 17, as a person aggrieved, he had to go before the court, before the DRT. I have lost my advisory capacity, but definitely I would.
Oh, your lordship was on this side and your lordship has seen much more than all of us. Your lordship knows what happens on ground.
So,
And your lordship is smiling only for that reason. I mean, your lordship knows lesser said is better. But Milords, let me say this. And Milords, I will rest my submission after Milords these 2 or 3 points. Your lordship will see para 7 of their petition for a moment. Kindly see para 7. They, Milords.
You read
Yes.
it out?
Yes, Milords, I will read it out, Milords.
With petition.
Milords, sorry, para 11 of the petition, not 7. Your petitioner states that petitioner was pursuing the appeal before the DRAT when on 9th June, several police officers barged into the land of the petitioner and started destroying the said land. And when the petitioner's director objected to such illegal act on its part, the petitioner was handed over a photocopy of the order impugned dated so-and-so passed by the ACJ. In the petition, Milords, when they came before your lordship, they accept that the possession was forcefully taken by the police. The bank, Milords,
I have recorded that in the order.
no, what's the problem? Let me come to the problem. Yes.
But I have recorded, that it is disputed by them that the entire possession has been given to the auction purchaser. They are now the difficulty is that I am not the fact-finding court.
No, I bow down, Milords, I bow down.
See, prima facie, the Panchnama gives an
Possession
idea, that the possession has been made over to you.
Please,
Now,
Milords.
see, I have not disturbed your possession by the
Milords,
interim
what has
order.
happened? Milords, may I just point this out?
Only what I wanted to preserve the property so that when the rights are adjudicated, it does not go as it is today. If you look into from an angle, you had no control over there, but the bank, if the petitioner alleges that the bank has played mischief, no one can also deny that, because a nationalized bank, they were aware from 2024 that this is the situation. They go before the ACJ and they are silent. They do not say anything. You had nothing to do because you are the auction purchaser. It was for them to give you possession. Now they do not speak in their application even one sentence about the pendency of the about the proceedings filed prior to December 2024, and also about the orders passed therein.
No, my lord.
They simply go before the ACJM and
No, my
say,
lord. We have received the order from the DRT. After the essay was dismissed, we have moved before the DM, and by the time in the month of 2025, they have filed an appeal before the DRT, my lord. We have not hidden
the
anything, my lord.
unfortunate part, I told you, the more you open your mouth, it is difficult. It will be disaster for your client.
Ma'am, we have in the list
So
of date we have stated, my lord.
you show from your section 14 application
Yes, my
whether
lord.
you have said anything about the proceedings.
No, the proceeding was
We-
over, my lord. DRT proceeding was
Oh,
over on 2nd
oh.
of December, and we have filed the
Sir,
application on.
Sir,
Yes, sir.
the little I have learned that you should not suppress any fact, and if there is a material suppression of fact, then it disentitles you of an order. Plain and simple.
My lord, I
give
will
you-
accept
I
all your
will-
orders, my lord. If
I will
I am
give you,
proven
I
wrong,
will
my
give
lord.
you, I will give you two Supreme Court judgments.
Ma'am, my lord,
Passed by
if I am
SG
done anything wrong, my lord,
Uh,
let me just submit in the point of dates I have given. The order was passed on 2nd of December 2024. We made an
Sir,
application on
sir.
28th of December 2024.
Sir,
Then where
what-
come we will
what-
say that there is a pendency of the suit? Because they have made an application of
Sir,
the
what
before the
prevented
DRT
you-
on 14th of
Sir,
January.
what prevented you from saying that this is the situation? There was a proceedings which has ended
But-
with the order.
My lord, we have submitted our application along with the affidavit.
I
They
told
have
you,
taken
I
the
told
application.
you,
There is no scope of submission, my lord.
I told you that day that
Yes, my lord.
you are after small borrowers who have a few lakhs of rupees, but when it comes to big bulls, you are not to be seen with a Section 14 application or any steps. Now tell us one thing,
Yes, my
why
lord.
will the nationalized bank in its application not say so?
Because in the application of the section 14, there are only 11 points to be stated, my lord. And we have to state as per the point and whether there is any pendency of the suit or not. At the time of the juncture, there was no pendency of the suit because the DRT has already passed the order and they dismissed the application. The appeal was filed on the 14th of January,
Very
after we have filed the
I
application. So
have,
where
I
is
have,
the scope of
I
relating that there
have,
is a pendency
I
of
have
the.
heard you, I have understood you very well.
Milords, may I say this? Milords, what is troubling today, your lordship, the most, and Milords, this is what I gather, is that the bank, of course, should have disclosed the fact that DRT is rejected. Number two, the ACJM in some form should have given them a right of hearing or considered their objections. On that, Milords, the SARFACI scheme, Milords, with greatest of respect, is very different from any other proceeding. And Milords, let me just cite one judgment. If your lordship is persuaded, Milords, very well. If your lordship thinks otherwise, Milords, I will not say a word. May I just, Milords, quote the judgment of the Division Bench of Bombay High Court, which is considered and affirmed by the Supreme Court later. Milords, may kindly see that judgment for a minute.
No, affirmed ki the SLP has been dismissed.
No, it's a detailed judgment of the Supreme Court where they say that we affirm the findings. Your lordship will see, this is the judgment of Phoenix ARC of Bombay High Court. Exactly the same question, almost the same situation. The only difference there was the tenant had gone. Today, Milords, the subsequent purchaser has come. That's the only difference. The question was whether they have a right of audience, whether they should have been made a party or not. Kindly see this judgment, Milords. And then I will show you the Supreme Court judgment, Milords, which affirms this. Your lordship will have para 1 and 2.
See, I am at this stage, I tell you, I don't want to go into the merits because then
Very
I
well.
will be usurping the jurisdiction of the DRT under section 70.
Because may I then say this? I bow down and I follow what is falling from your lordship. My only difficulty is
Because
they
the
have
moment,
misused.
the moment from the High Court, I make an observation.
That will go against us or them, whoever is the party.
Yes, why should I, why
No,
should
Milord,
I?
the problem is this. Kindly visualize, Milord, what has happened. After they came to your lordship, I was already in possession. Right, wrong, good, bad. The fact of the matter is I was in possession. Now, Milord,
That's what I wanted to preserve.
No, Milord, but what has happened after that, Milord?
Because
Your lord.
I injuncted you and I had injuncted them also.
No, Milord, that's the problem. Kindly see the order. Your lordship had only injuncted me and the bank,
No,
and
no,
they have
no.
misused the order. Kindly see, Milords, the order. Your lordship's order of 11th March, 11th June. Kindly see, Milords, last page. And that's where the whole problem arose. That's why the police didn't help me. As long as Milords can protect this point, I have nothing more to say, Milords. Your lordship will see page 7, the last page of that order, in the aforesaid facts and circumstance.
Yes, I had
Milords, I'll tell you the problem, what had happened,
no,
Milords.
now I recollect. Initially, I was bent upon to injunct them, but I later on thought that if I injunct them, then probably I will be holding or observing that they are also in possession of a portion.
No, Milords, this was very well intended. Milords, but the problem, what has happened is, because the order is framed in this manner, they, Milords, broke the tin barriers. They entered. When I went to the police said there is no injunction against them today. So, Milords, what I'm requesting, and I've gotten your mind, Milords, what your lordship has in mind. All I'm saying is, as on the date when they came before your lordship, the status quo should be maintained as on that date, Milords. Whatever has happened after that shouldn't be, Milords, touched.
See, that is the whole difficulty. You objected to. I was initially bent upon to pass an order directing status quo.
Please, Milords.
But you objected to, then it also came to my mind in the second thought. If the status quo is not defined, then the difficulty will further arise.
Milords, but kindly consider my position today. My plight is such that they have somehow misused, Milords, if I can say that, Milords, your order. And today, Milords, they are claiming that they are in part possession, which cannot be the case.
Very well. Mr. Chaudhary?
May I submit, my lord? Well, my lord, I'll not take much time, my lord. My lord, in my list of dates, my lord, give me a 2-3 minutes, my lord. Kindly my list of dates, my lord. In clause number, serial number 11 and 12, my lord. My lord, in serial number 11, my lord, the 11th March 2019, the section 17 application of the first round before the DRT was dismissed, which was filed, my lord, it was filed in February 2019. First surface is 17. Then, my lord, 11th March.
When was the auction?
Yes, 12th March. Just it is 11th March, the order refused. Section 17 application. 12th March auction proceeded. This is number 1, my lord. Number 2, my lord. Before 11th March, before the 12th March, my lord, I have published notice through a daily leading newspaper in Hindi, English, and every vernacular language, stating this fact. So, my lord, despite the knowledge, knowing everything, the auction purchaser purchased the property on 12 of the connivance of the bank. This is number 1. Number 2, my lord, all through, my lord,
See, Mr. Chaudhary, the difficulty is
Well,
that I am
You
not,
cannot. Malad,
I am not the fact
Malad,
finding
my
court.
Malad cannot. Malad cannot. Malad, I understand. This is the reason, Milord, of the very first day. Kindly recall, Milord, at the time of mentioning, Milord, you have a very, very limited jurisdiction, Milord, with regards to a 227 while exercising this power, Milord. I said, knowing fully well, but not kindly see, appreciate. My application was rejected in December, Milord. I preferred an appeal before the DRAT, Milord, pending. I have demonstrated that the last entire week there was no court, Milord. So, Milord, at this juncture, Milord, I have no other option. This is the reason 227 application was filed and invoked before your lordship, Milord. Number 3, Milord, all through, I said it is barred by 31. Which your lordship said at least a call for report from the bailiff. Milord, my list of documents through a RTI event, I did not obtain a report from the bailiff. Through RTI, bailiff said as on date, the property is a Milord, the agriculture classification is agricultural land. So, Milord, number 1, coupled with that, Milord,
Question is,
coupled with that, I am cultivating.
no, no.
Milord,
Question is, see, today the borrower is not to be seen, and absolutely correct. He has received the money.
she did not appear.
She has washed off her hand. Now the issue is,
Milord, your lordship is not audible.
Lordship is not audible now.
Sorry, Milord. Milord, the audio has gone. Your lordship's audio is switched off. I can't hear Mr. Chaudhary.
Hello.
Yes, now you're audible, sir.
It is rightly at the very relevant point you did not hear is good. And it is the duty of the bank, incumbent upon the bank, to verify, to ascertain the document which I am relying upon the borrower, which the bank did not.
But today that's not the issue anymore.
This is have I ever uttered a single word when you were on, please, Mr. So, Milord, so now it is still there, it is an agricultural land, it has to be ascertained, adjudicated, matter pending before the DRAT.
no, the difficulty is that DRT
Yes.
has given a finding.
Yes.
Yeah.
Now, whether
Already
it is correct or not has to be gone into at the DRAT.
I have a right till audience till Honorable Supreme Court, Milord. Unless it is adjudicated and reaches to a finality, Milord, it cannot be said unless is a limitation period has already been over. Cannot say it matter reaches to a finality. So at this juncture, Milord, my application pending before the DRAT, that challenging the order of the DRT, the Milord kindly give me that time which is fixed before July 27 July 29 June July.
No.
Just
Lord, I have no difficulty in what Mr. Chaudhary is saying. Your lordship knows he can agitate all points. Today, Milord, we are on a very limited question.
Just a second. Let me complete. So, Milord, the next date is fixed on 29th July.
No, that is before the DRAT.
DRAT.
But your challenge.
No, Milord, I have a twofold. Milord, kindly see. If I am succeed before the DRAT, then section 14 will not come. Section 14, which they filed before the learned SCGM, definitely has got, it became infractuous.
You are missing one short link. Today, the court of original challenge in respect of section 14 is DRT under section 17.
Exactly, Milord. Milord, kindly
Now
appreciate one thing.
Today,
Milord, kindly appreciate.
what was before the DRT? Before the DRT against which you preferred an appeal was adjudication of your right.
Yes.
At that juncture, the section 14 application was
Not there.
And section 14 application, in the section 14 application, order was also not passed.
Yes, Milord.
Now, and since the order was not passed, the execution of the order is also not
carried out.
not carried out.
Yes, Lordship.
Now, the difficulty is that I assume jurisdiction because for the limited purpose. Now,
Your Lordship
today-
want to
today-
send me back to the DRT.
Yeah.
I have no difficulties, my lord.
No, you're in DRT because section 14 application has to be challenged before the DRT.
My lord, I have no hesitation, no demurrament. My lord, kindly appreciate one thing. I have a appropriate jurisdiction in section 417 before the DRT. No doubt, no quarrel. The moment section 17 application I will file, DRT will say, look,
What the DRT will
Well,
say,
kindly-
it's not our
No.
lookout at
my lord,
this
I
stage.
will rather, my lord, I am seeking, my lord, let my appeal is pending before the DRT.
See, I have assumed jurisdiction in respect of section 14 order,
Yeah.
not in respect of the DRAT order.
No, definitely
So,
not.
so
Definitely not.
I
Not.
can pass a direction in respect of the section 14 order,
Lordship,
but I
okay.
cannot.
Lordship, no problem. I'll go back to the DRT by a section 17, my lord. My lord, kindly appreciate one thing.
I will-
Because we know Lordship's order now. I have Lordship's order. Now, my lord, kindly see what your Lordship, what I said, demonstrated. My lord, and suddenly it is the admitted fact. Till 9th June 2025, I was cultivating the land in entire of 17 bighas. It's huge land. It is admitted fact. No one can dispute.
No, nobody is admitting this. I'm sorry. Where is this admission?
Say, why section
Mr.
14
Chaudhary,
then? Why
Where is
section
the
14?
admission? 17
Why
bigha, where
section
is the
14?
admission?
What they
No,
are
no, no.
saying, I do not know.
No. He was cultivating. All of this is just putting in words. That's not even in their application.
All right, I am not doing anything. All right, I am not doing anything. I was enjoying.
See, did you inspect the property?
No, Milords, on the papers, Milords,
How
he has to
they
at
can-
least make
how they
an
can-
averment.
How they can? Before. No, yes.
We have the photograph.
No one is disputing.
No. See, in any auction sale, in the sale notice, it is given that on this day,
Symbolic.
the property will be left for, will be open for inspection. Did you take that inspection?
Yes, Milords, we took that inspection, Milords.
Where
Milords, I am not disputing.
where are the photographs at the time of inspection?
Inspection. Let
Inspection.
bank
Milords,
produce it.
Inspection is something different. It's only after section 14.
Inspection. At the time of causing an inspection,
দেখতে চাই না।
Are Baba, at the causing of an inspection, let bank submit.
Take down.
Milords, may
That
kind
I am coming
hear me on a
to
minute,
your lordship's order, my lord. Now what happened, my lord? Your lordship, I said that demonstrated. This happened, my lord. 9th June. I came before your lordship on 10th June. Matter was taken up on 11th June. 11th June, your lordship had restrained them at 12:30 till the order was, even it was uploaded at night, even 9:30, something like that, my lord. That was, my lord, on Wednesday. That next day, my lord, Thursday. There was an injunction, my lord. They will not change the nature and character with regards to a post. What, Mr. Mittu?
I will hear you. I will hear. See, the
Sure.
difficulty is that your leader is already online.
He is the father. So that liberty God will. He is the ML son, not Mr. Mittu. So, my lord, kindly visualize, my lord. So, Wednesday, order uploaded at night. Thursday, Friday, my lord. My lord, we are contemplating our even content application. We have all video recording, everything, my lord. They have stretched a boundary wall by our construction by putting a pillar and even, my lord, tin structure, my lord. Which till Friday. We have no other alternative, my lord. We approached to the police station, my lord. I did not use my good office, my lord, even. Me, my lord, I'm very candid.
I don't know why he's saying that.
I
I
said,
don't know why he's saying that.
I said,
That's very unnecessary. I mean,
yes,
I
that
don't know, Milords,
I did not,
why
I
such a
must be
state?
candid before this.
No, why such a statement is made? Is he
Yes,
standing as an
yes,
additional advocate general? Is he standing as an additional advocate
What
general?
statement I will make, you will dictate.
No. This is most unfair. Most unfair.
What happened then? I sought a police protection. They laid the order in a letter and spirit, in a strictest sense, be carried out. This is my lord, the letter before the my lord, concerned police station and before the concerned commissioner of police, my lord. And I lodged a FIR even, stretching, my lord, annexing all these, my lord, videographic, my lord, with a pen drive, that how the order by your lordship has been flouted and they have constructed the further stretch of boundary wall, my lord. So, my lord, in these circumstances, my lord, as Lordship Malik, kindly, my lord, the order which your Lordship passed, my lord, kindly protect me. Otherwise, my lord, what is the purpose of, my lord, granting the order of injunction? Let,
my lord, so-
my lord, my prayer before this concerned police station and the commissioner of police for deployment of police person at my cost be considered also. So, no
my
one
lord,
will
if,
violate. My lord, I will not commit a single violation, my lord. Let them
my lord,
also undertake pledge that they will not commit a single violation, my lord. This
I have no
cannot be done
difficulty, and
unwanted.
that's a
Otherwise,
fair suggestion.
situation will be.
That's a
Yes,
Mr.
that's
Chaudhary, that's
I
an extremely fair suggestion. I am grateful.
Yes.
I am grateful. That's an extremely fair suggestion. Milords, what is implicit in this is that I today have possession on the piece of land. That, Milords, your lordship may clarify and let there be 100%
I
status
will
quo.
not,
If
I
they
will
want
not
to
clarify.
avail other remedies.
Yeah, I am not a fact-finding court. How can I
No,
clarify?
Milords, he's admitting to that. He's admitting to that. That's what he's admitting. That
What
I am in
admitting?
possession.
Take down. I have heard. No.
Milords,
Please.
one sentence, Milords, your lordship may not just, Milords, put me in a position because I didn't have the benefit of the petition on the first date. Milords, that order, Milords, you have seen what the order was passed. Today, Milords, the only difficulty is, admittedly, bank took the possession, right, wrong, good, bad, he has a remedy. Your
You have a
lordship,
remedy. If you are successful,
no, but they can't
if
use
you
the
must,
case, Milords, as a platform to then,
Right.
Milords,
I have heard the matter enough. No further hearing. Take down. This revisional application was entertained in a scenario.
my lord, the DRT's notification shall I file?
No. He was where the Debts Recovery Appellate Tribunal, in short DRAT, constituted under the Debts Recovery and Act.
Surface securitization.
No, Debts Recovery Tribunal is under the
DRT Act, Milords.
DRT
Yeah.
Act. In short, such and such was not functioning as the chairperson was on leave. As a consequence whereof, an appeal at the admission stage filed by the petitioner before the DRAT challenging the order of the Debts Recovery Tribunal dated 2nd December 2024, passed in an application under section 17 of the পুরোটা লিখে সার্ফেসি অ্যাক্ট করবে। আগের দিনে অর্ডারে সব করা আছে, ঠিক আছে। The application was also entertained as কি বললাম কি বলেছি
As a consequence of an appeal at the admission stage filed by the petitioner for the DRT challenging the order of the Debts Recovery Tribunal passed in an application on section 7 of the
Surface Act was adjourned on was adjourned on 22nd May 2025 till 29 July 2025. Full stop. The bank, the opposite party number 1, bracketed bank, after the dismissal of the application under section 17 made by the petition, after the dismissal order, after the after you will know,
Number one, right? After dismissal of the application. 17 we
VDA order dated 2nd December 2024 made an application under section 14 of the Surface Act. In the said application, the bank has, however, not stated about the proceedings initiated by the petitioner and its dismissal on 2nd December 2024. Although this was required to be brought before the concerned magistrate. Post. The appeal against the order dated 2nd December 2024 was preferred by the petitioner on 16 January 2025, and as such it was out of time. The appeal has not yet been admitted. Has not yet been admitted despite passage of more than 6 months time, and the next date is only on
29 July.
29 July 2025. The bank, opposite party number 1 bank, by obtaining an order on, when is the section 14 order passed?
7/4/25. 7/4/25.
7th April 2025.
and by obtaining an order. 17.
In its application under section 14 of the Surface Act, implemented the same on 9th June 2025. It is the case of the bank that with the aid of the said order, the possession of the entire property has been made over to the auction purchaser, being the added opposite party number 3. Although, the fact that possession of the entire 19 acres of land being the subject land being made over to the auction purchaser was disputed by the petitioner, but this court
As physically impossible.
uh,
Disputed as physically impossible.
Oh.
Practical.
as we say, but this court, while exercising jurisdiction under Article 227, and that too in a limited scope for the facts as aforesaid, had no occasion to go into the fact finding. This court, therefore, on the principle, এই ওখান থেকে দুটো চেম্বার থেকে দুটো বই আসে, আসলে দেখো 2002 একটা এসসিসি আছে আর 1993 ওই 3 সাপ্লিমেন্ট এসসিসি।
Because if it's helpful, we have some judgments on the scope. Because I can just pass on if it's helpful. We have a 3-page submission also on this.
No, it's not required. I'm not going into it.
Yes, only on the jurisdiction. Because if your lordship wants to quote, I have some judgments. Is all I'm saying.
It is going to court, how do you know?
Jurisdiction, see, the judgment of 2002, I had
Noted.
I have quoted the words that no person can be left remediless.
Limited. Please. I
That
bowed.
is- and if the substantive law does not provide for a remedy, then
Then your lordship's doors are open.
কি বললো? হ্যাঁ?
Although that portion of the entire 19 acres of land in the subject land being made over to the auction purchaser was disputed by the petition, but this scope was exercising that will be a limited scope for that therefore said had no occasion to go into the fact.
হ্যাঁ, কি বললো? This court,
Therefore, on the principle.
as laid down in 2002 6 SCC, /16, ঠিক আছে? To the effect dash I that every wrong must have a remedy and every right to relief must have a forum for enforcement. Had passed an interim order to protect the nature, character, and possession of the property in question, so that the right to challenge the order under section 4, passed under section 14 of the Surface Act and the order dated 2nd December 2024 passed by the DRT in favor of the petitioner is not lost. Full stop. As submitted by the opposite party number 3 by citing তোমরা এমন লেজুর লেজুর করে জুড়ে রেখেছো না, এটা ছিঁড়ে যাবে নাহলে ওটা পড়ে যাবে। হ্যাঁ, কি বললাম?
As submitted by the opposite party number 3 by citing
The judgment reported in (2023) 1 SCC 662 ওই আগের দিনের অর্ডারে ওটা দেয়া আছে, দেখবে that an order under section 14 of the Surface Act has to be challenged under section 17 of the Act before the DRT. একই সেন্টেন্সটা বললাম এটা।
as submitted by the opposite party by citing the reported information that an order under section 14 of the Surface Act has to be challenged under section 17 of the Act before the DRT.
And taking into consideration that the DR80 is the chairperson
of the DR80.
Presiding over the DR80 has resumed office, I am inclined to send the petitioner before the DRT to challenge the order dated ওই কত এপ্রিল জানো? 7th April 2024 before the DRT under section 17 of the Surface Act, as also grant liberty to the petitioner to approach the DRT for preponing the hearing of its appeal.
Yeah.
I refrain to go into the merits of the matter, as any observation made herein may go against either of the parties and will also amount to usurping the jurisdiction of the normal forum. Full stop. However, at the same time, at the same time, if the nature and character of the property in question, nature, character, and possession of the property in question is changed during the interregnum, then the proceedings that may be filed by the petitioner under section 17 of the SARFAESI Act or its right in the appeal pending before the DRAT may likely to be jeopardized. In the aforesaid facts and circumstances, the petitioner is granted আজকে কত তারিখ? 17 granted ten days time from
There has been between there's a holiday.
what holiday? No, 27 June Roth, but Roth there is no holiday.
DRT.
DRT is holiday in Roth.
Also, make it a 10 days. I'm thinking about 10 days plus 5, 10, 2 weeks now.
A fortnight from date
Yes, sir.
to approach the DRT to challenge the order passed by the learned magistrate under section 14 of the SARFAESI Act by filing an application under section 17 of the said Act. The interim order, which was passed on 11/6/2025 shall to the following effect, quote করে দেবে following effect. That the opposite party number 3 dash auction purchaser that the bank and the opposite party number bank ব্র্যাকেটে দিয়ে the opposite party number 1 and the auction purchaser being the opposite party number 3 are restrained by an order of injunction from dealing with, disposing of, and or changing the nature, character, and possession of the property in question, the particulars whereof are more fully described in this application, shall continue for a period of 3 weeks from date, full stop.
Or without passes the interim order, whichever is earlier. Whichever is earlier.
Which?
Or passes the order by the DRT, whichever is earlier. But I
Milords,
was
may I?
all right.
That will create
Milords,
since
Milords, may I request this?
just a minute, please wait. Don't be impatient.
I'm sorry, Milords.
Since the opposite party number 3 bracket auction purchaser has alleged that the petitioner by taking advantage of the interim order just please has tried to disturb the possession of the opposite party in respect of the property in question, which is however denied and disputed by the petitioner to petitioner with the petitioner. I direct the local police,
May I put it down for a second?
just a minute, local police authorities and the concerned superintendent,
Commissioner,
concerned
Commissioner
commi-
of Police.
uh,
Deputy Metropolitan Commissioner.
concerned commissioner of the police district to see that neither of the parties do flout the interim order. It is also made clear that in the event any of the parties are interested to seek police help.
Sir, already kindly indicate, already I have made an application.
No, interested.
Already I
We've
made an
also made applications.
Interest,
This was not clear that. State which seek police help.
police help by deputing police personnel and or police picket may apply to the concerned police officer for necessary assistance, if not already made.
But not assisted. For implementing the order passed by your lordship.
No.
Sir, the assistance interpretation mela. So mela, the order which your lordship passed to preserve and to protect for the police protection is required, not for other purposes mela.
Yes. What do you want to?
Milords, I'm grateful, Milords, for the order. Milords, all I'm saying is let there be a status quo as on 11th, when your lordship first heard, for all parties. Today, Milords, the order doesn't restrain them. Your lordship's order only restrains us, Milords. All I'm saying is let there be a status quo as on.
No. If I pass that order, it will go against you, because then I will be recognizing their right somewhat in respect of the property.
Milords, they may sell the property today, is what I'm saying. I mean, what has happened, they may also sell it today, basis this sale deed that they have.
Kindly undertake mela. Mela, that for implementation of the order, not for.
Milords, on a lighter note, Milords, Milords, on a lighter note, may I say this?
কি বললাম কি
For implementation of the order.
It was not clear that in any of the parties are interested to seek police help by deputing police personnel and or police ticket may apply to the concerned police officer for necessary assistance.
for implementation of this order.
For the implementation of the order.
Milords, may I?
Handle na. Extra कोई handle नहीं कर देते.
On a Milords, on a lighter note,
So.
আচ্ছা ওখানে একটা দিয়ে দাও দ্যাট যে ওখানে দিয়ে দাও যেখানে তুই ইনজাংশনটা দি না ফার্দার মোর কমা to prevent future complication and multiplicity of judicial proceedings, the petitioner shall not
Create third party interest.
shall not deal with the
Sir, create third party interest.
No, 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 no. That's the whole point.
deal
I
with
didn't say I will not create third party.
deal
No, no, deal with also.
deal with deal with the subject property by dint of the sale deed dated of the September 17. Order.
Because 30th March 2017.
That
Third-
keep this land. But I will not say.
30th 2017.
Yes, no. I will keep this land.
30th
Nothing.
Not to purchase.
But there is a too much apprehension about.
For a period of 3 weeks from date.
Grateful.
Milods, there's a CAN application that we moved that can be disposed, Milods. There's a CAN application for
The
CAN 1.
The connected application being CAN 1 is also disposed of. CO
Dispose of mallet, I even saw just now you were in court. Even saw
Last night you were served.
I slept at 10. They served it to my learned junior at 11. I do not. I wake up at 3 a.m.
nothing further remains to be adjudicated.
Second round of my
The item number 4 of your lordship's list.
Yes, it will be called on, it will be called on. Let me see.
Item number 2 is there also.
Milods, item 2 is part heard, Milods.
Item 2 can wait till tomorrow.
Please, Milods.
Item 2 means that
710, Milods. Rejection of 710.
yes.
On that invoice, your lordship had heard the matter yesterday.
Yes, Mr. Seth from was
Gujarat, yes, Milods. Milods, I think his junior is there, Milods.
let it be tomorrow. This item, Mr. Seth, are you online?
Mr. Seth is on before High Court, so maybe kept tomorrow or.
Very well, tomorrow.
Can we request item 1 tomorrow, Milods? Because since your lordship have already heard this,
Yes, it will be item 1.
grateful, Milods.
Obliged.
Just a one, no mentioning. Which is your item?
4. Item
3, who is in 3? Item 3? Item 3, see, I have gone through the judgments. To be candid, I will add some further flesh to the Delhi High Court judgment for entertaining a 227.
As per the.
And so far as the other part, I will deal with it. I will not say. But,
Those judgments are absolutely irrelevant.
which one?
Milord, that Delhi High Court judgment, Kelvin air conditioning versus Trump reality. That's absolutely irrelevant, Milord. Absolutely. And from that appeal, my learned friend has referred another judgment, Milord. I brought that Deep Industries Limited, Milord. That
Sir,
is also irrelevant, Milord.
Sir, the difficulty is that according to you, all judgments are irrelevant, but it is a pronouncement. Deep Industries is by the Supreme Court.
Yes, that is, Milord, latest guidelines are framed in by Justice Aniruddha Ghosh and Pardiwala in the latest 2024 judgment that I have handed over, Milord. 2000
point of amendment.
Yes,
Not
when
only
can
for
Order
amendment.
6 Rule 17 be applicable, Milord?
That is
you
on,
and Krishnamurthy and
see,
Justice.
that is on a different footing. That is on the merits of the case. Now I have seen the order of the arbitrator I am not expressing my mind
Yes,
now.
yes.
Because it may so happen that instead of wasting time, I will dictate it and I will read it tomorrow.
Millard, may I have also placed before my lord those judgments where the financial capacity, if they should have the financial capacity before agreement, before entering the agreement, that judgments also must be looked into, because that is the latest
Sir,
judgment.
my understanding of law is very limited. Now, amendment, in course of amendment, if I comment on the merit of the matter, then I think I will be
Then-
transgressing into the jurisdiction of the arbitrator.
There, it is clearly said that they, 227 and 226 has not, no jurisdiction over the arbitral tribunal, that same infrastructure I have handed over the last tribunal, same infrastructure must stop till.
দিয়েছে সেই ইনফ্রাস্ট্রাকচার দিয়েছে দেখো তো ফাইল
Yes,
আছে
Stray infrastructure has been dealt with in deep industries. He's again relegating the issue back to the history. History now has a present, which is Kelvin air
They are absolutely irrelevant. Kindly see deep industries pan 13. I'll distinguish those judgments. I'll distinguish. Para 13 of deep industries. Neither 227 nor 226 has to be is applicable in case of arbitral tribunal. I have brought deep industries. Para 13 it is mirror.
এই দাও তো বড্ড বাজে বাজে বকছে পড়েই নি জাজমেন্টটা এই আমার ডিপ ইন্ডাস্ট্রিজের জাজমেন্টটা কোথায় গেল আমার মার্ক কপিটা হুম দেখো লাল পেন দিয়ে মার্ক করা আছে দেখো সুপ্রিম কোর্টের জাজমেন্ট থাকবে
And we have also cited, Kelvin air conditioning. That is also given back. Can you distinguish two?
চেম্বারে রাখা আছে কিনা কি হলো কোথা থেকে গেল রে ভাই এটা
May I hand over my copy, Lord?
No, no. I have, for your kind information, I have read. I want to show you the portions. Huh? Deep industry has it? Yes.
This being the case, I will go down whatsoever. Petition, what we filed under 227 of the Constitution, against the orders passed in appeals under section 37, the entire process will be delayed. Entire process will be delayed and would not come into future for many years.
Yes.
At the same.
Yes. So please come to. Come to paragraph 24. that deals with revision under section 150. Now we come to 227. Come to paragraph 17. 17. Yes. This being the case, there is no doubt whatsoever that if petitions were to be filed under Article 226, 227 of the Constitution against orders passed in appeals under Section 37, the entire arbitral process would be derailed and would not come to fruition from many years. At the same time, we cannot forget that Article 227 is a constitutional provision which remains untouched by the non-obstant clause of Section 5 of the Act. In these circumstances, what is important to note is that though petitions can be filed under Article 227 against judgments allowing or dismissing first appeals under Section 37 of the Act, yet the High Court would be extremely circumspect in interfering with the same, taking into account the statutory policy as adumbrated by us herein above, so that the interference is restricted to orders that are passed which are patently lacking in inherent jurisdiction. You have read the judgment, you are placing one portion, you have not read the entire judgment. You tried to place a portion of it. Unfortunately, you found it difficult because I have read it. See, here I am minded. I am minded to hold that 227 is permissible. Because see, if you look into the scheme of 37, an order either allowing amendment or disallowing the amendment is not an appealable order. Now, I had just now in the morning referred to this judgment of 2002.
Remedialist.
2002.
On the point of
No.
Life Insurance Corporation is also on.
No. 2002 is Dhannalal versus Kalawati Bai and others. Here, the Supreme Court in paragraph 25 has clearly stated, otherwise they will be left without remedy, keeping in view the three relevant principles. One, that every wrong must have a remedy and every right to relief must have a forum for enforcement.
They have every right to challenge the order, but not before 227, 226. They can challenge in other forum.
What forum?
Other forum, they can go before the district judge. That is not my lookout, my lord. But they cannot come under 227 and 226.
So tell me, you are arguing which forum?
My lord, my lord, that is.
You say,
that is,
you have to say.
That is their problem, my lord.
No.
But
It is your problem because you are arguing a case. Then you have to say that yes, this is the alternative forum because under Article 226 or 227, if the statute provides for a particular forum, only in that case, because the statutory alternative forum is available, he should be relegated to that. L. Chandra Kumar, followed by Saurabh versus Ames.
Yes. In Chandra Kumar, if there is any alternative forum, this.
Now tell me, suppose this order was otherwise. The amendment was allowed. You are the respondent. Then where will you go to challenge that order?
Let us
see, when you are arguing, argue like an officer of the court because your role is to assist the court.
But Miller,
you are not engaged in a club club feud.
Miller, going by the judgment placed before your lordship, Miller. Here it is. If the High Court.
No, tell me. I give you the example, the reverse.
Yes.
Then today, if your argument is just substituted by him, where would you go to challenge? Now, the other part is that in section 16, which was discussed in Deep Industries, section 16, it is clear, prior to Deep Industries, it has been held, and the statute is also clear that if you challenge the jurisdiction, you cannot further challenge it, you have to wait and take those points in 34. Now, this is not the statutory mandate or the relief allowed. On the contrary, suppose I disallow an amendment or as an arbitrator or entertain an amendment. If somebody has to wait till the award is passed, then the whole object of the act will get frustrated because after the final order, if it is found that no, the amendment has been wrongly refused or has been incorrectly allowed, what will be the fate of the proceedings?
I have a judgment before your lordship, Lord, Life Insurance Corporation. Here the grounds for entertaining order 6 rule 17 has been explained.
See, why grounds of order? See, you are saying something on a different. I am on the point of maintainability of 227, and you are going into the ground of merits. Have I ever said? I told you that I will not speak as of now regarding the merits of the application.
If this amendment is allowed, my lord, kindly visualize.
See, why are you thinking that this amendment will be allowed?
Just
what has given you this feeling?
Millard,
have I expressed my mind till now?
Millard, absolutely not. Millard, if this, Millard, it will frustrate my statement of defense. Millard, my statement will defense will go.
It will have a right of filing.
Come tomorrow or day after tomorrow.
Millard, kindly passes the order.
Lastly, my lord,
Kindly passes the order.
in
This needs no more discussion. He's only
my lord, last
not
judgment,
wasting
my
this
lord,
honorable
never
court's
get to
time.
my lord, passed by Supreme Court, my lord, Dalbir Bhandari versus H. Bedi. My lord, I have written down.
2006.
Yes, here, my lord, it is absolutely clear that
See,
2000 orders.
unfortunately, I keep myself updated till now.
Yes.
After elevation, I
I
thought.
know, sir.
After elevation, I thought
All
I will.
these things are known to your lordship, my lord.
I
But
thought of reducing by, but you people have
this
made me.
revisional application is
you people-
absolutely not maintainable and should be dismissed with
people have made
exemplary
me,
cause, my lord.
have compelled me to read more. Now, that is only merit. That is only merit. That I will look into.
My lord, kindly, my lord, these judgments which I have brought before your lordship, that can be taken into consideration, my lord.
Very well. Tomorrow,
Lord,
I
for
think
order.
I will.
For order.
For order.
Deeply appreciate.
But only, I'll take only 2 minutes. Only 2 minutes. Let, item 4. Let, application under section 8. Milord, I was the.
Section 8 of.
For WBL Act. For preemption, I was the petitioner. Milord, the learned civil judge junior division as well as the first appellate court both dismissed my application on the ground that despite having knowledge of sale, I failed to purchase. Therefore, my exercise of right of preemption cannot be allowed. Now, the basis of this conclusion was a Gramin Shalishi notice.
You serve the other.
Milord, I will only pray, Milord, for stay of the order. Milord,
Come tomorrow. Serve and come tomorrow.
Milord, by one day, Milord, it will be difficult. It's
Thursday?
Alipurduar.
Thursday to
Milord,
the after hearing the petitioner.
Milord, kindly stay
And
it
in,
for 2 days. Milord, they're
and in,
constructing upon
and
the
in
land.
particular, since the petitioner is seeking an interim order of stay, let a copy of this application be served on the opposite parties as also to the learned advocate who represented the opposite party before the trial and the first appellate court. Let this matter appear on Thursday.
Let the appellate order be stayed, at least, Milord, till this Thursday. Milord, I wouldn't have insisted, Milord, only because of
Mr.
the
Ghosh,
fact, Milord,
come
they are raising
Thursday,
constructions.
come Thursday, I will.
Milord, since yesterday, they are rapidly raising constructions. Milord, Milord, kindly, Milord, stop this. Milord, 2 days, Milord, heaven will not fall. Absolutely a perverse order. Milord, notice is
2
defined.
days in the monsoon, they won't be able to.
Milord, they're doing it. Milord, they're doing it. Milord, I say this with responsibility. Otherwise, Milord knows I don't unnecessarily, Milord, insist for interim orders. Milord, limited, Milord, at least till day after tomorrow. If they appear, that doesn't happen, Milord would consider. Milord, at least, Milord.
ঠিক আছে একটা ইয়ে করো the after hearing the petitioner and considering the materials on record, and in view of the allegation, which paragraph you have made the allegation?
Milord, that allegation is not in my pleadings, Milord. It's para 10, Milord. I have.
Sorry, that allegation has to be there.
Milord, allegation I have not made. This.
No, আগের অর্ডারটাই থাকবে, sorry.
At least, Milord, for 2 days.
Item number 12.
Mr. Ghosh, as a civil lawyer, you know, there has to be.
This list, item number 12.
Grateful, Milord.
Listed on tomorrow, Lordship.
What is the urgency?
I just that the matter is for expeditious trial of the acted matter, Lordship.
Yes?
Expeditious trial of the acted matter, Lordship, filed before the district judge Darjeeling. Civil location date was fixed for hearing, Lordship, but that day the PO on leave, Lordship, and the in charge PO is not taken the matter.
Not that urgent.
So, Lordship,
Not that urgent. See, I can tell you from my experience, if I look into the order sheet, I will find that you had on several
no.
occasions asked for adjournment and got the matter adjourned.
Kind Lordship, I want kind Lordship, kind Lordship.
Because all the entire order sheet will not be before me.
No, enter order sheet, file Lordship, enter certificate to be filed Lordship. The matter is that Lordship.
That's where
Petitioner intend to file the matter.
Tomorrow I will look into. Tomorrow I will try to sit a bit for a bit more time.
Lordship, looking for upgrade.
Milords,
Item number 1, under order. Lordship, item number 1, I have for the respondent. Lordship, in this matter, there was this settlement going on.
The last week, your lordship had given us there was an adjournment for 1 week for settlement. Lordship, the settlement is almost closed. Lordship, today was fixed for filing of terms of settlement. The terms of my client has traveled from Calcutta yesterday evening. He's at Siliguri today. So I'll form the terms of settlement within tomorrow, Lordship.
Terms of settlement, not, this is what you are making a mistake. Under the appellate side rules, you have to file a joint petition. You have to file a petition incorporating the terms.
Incorporate terms and conditions.
Yes, that these are the terms on which the matter has, and it has to be by way of a joint affidavit.
Yes.
Unlike original side, I was telling in the morning, unlike original side, in original side, you file a terms of settlement, which is duly stamped and punched. It can be taken on record and a decree can be passed on basis thereof. But in the appellate side, you have to make a joint application. It will be through a joint affidavit.
See that his client after observation has come back from Maharashtra only on yesterday night. Today it will be finalized. After tomorrow, both the parties will swear and give it and other. Later the matter will fix day after tomorrow at 1 p.m.
We'll file the joint petition.
Let it be day after tomorrow. We are not fixing any time. But you come, if it is settled, you come and mention, we will take it up.
Yeah, tomorrow. In the department itself.
On the joint prayer of the parties and to enable the settlement to fructify. The matter is adjourned and shall appear. কেন ওই মুশকিলটা কি জানো তো, সেটেলমেন্ট করে দেখবে অ্যাডজার্নমেন্ট হয়ে সাইকিট বেরিয়ে চলে গেল।
What this matter is concerned, a transaction dealing with huge amount and 50 lakhs amount is already on record. They have submitted the 50 lakhs.
I believe that
What is 1 crore?
Let us not go into the merits. If you settle, you settle.
Lordship, I believe the record, the checks are on record.
Whatever may be, if it is settled, it is settled.
Item number 2. Undertake the cases for admission.
You are appealing. এই ডেথ রেফারেন্স কেসগুলোকে ইয়েতে তুলে দিও তো, কেউ অ্যাপিয়ার করছে না, যদি লিগ্যাল এডের দরকার হয় তাহলে করে দিয়ে যাব, না হলে ওটা এই সাবকিটেও পড়ে থাকবে। মুশকিল বুঝলে, ওই পারতো ডেথ রেফারেন্স গুলো কেউ অ্যাপিয়ার করছে না, এগুলোকে ওপরে তুলে দেবে কালকে। হ্যাঁ, আরো দুটো আছে না? দেখো একদম
এনে আপনি লিখেছেন কি জেল অ্যাপিল, জেল থেকে
কেউ তো নেই স্টেটে উইথ অ্যাপিয়ারিং ফর দি স্টেট। ইয়েস,
এটা কি জেল অ্যাপিল? দেখুন তো জেল জেল না, ওরাও একটা ফাইল করেছে, সেটাই তো বলছি। অনির্বাণ ব্যানার্জি, না অনির্বাণ ব্যানার্জি হয়তো জেল অ্যাপিল আগে হয়তো ইয়ে দিয়েছে, মানে তাকে মোকালতনামা নাকি।
who is the public prosecutor? Ask him to be present. We are passing it over. Ask him to be present. হ্যাঁ, পিপি কে আছে খবর দাও তো। এখানে ডিভিশন বেঞ্চ বসে আছে আর পিপি নেই।
অনির্বাণ ব্যানার্জি, who is অনির্বাণ ব্যানার্জি?
No, where is the public prosecutor? Madam, you are appearing for the state. Where is the public prosecutor? whoever it is a death reference appeal. No one is appearing on behalf of the state. This is the see, because if it is no one is appearing for the appellate, then we have to engage a advocate to the SLSA or DLSA. Why is the public prosecutor not there before the division bench? Ask him to be here. ডাকো পরেরটা ডাকো।
Item number 4, under admission of criminal appeal. Item number 4. Item number.
What is the matter? Who is for the state? এটা পাস ওভার করো। দেখবে ওই অদিতি অ্যাপিয়ারই করে না, কোনোদিন দেখবে না, ঠিক অর্ডারে নামটা ঢুকে যায়। ওটা বন্ধ করছি আজকে।
Item number 5.
অনেক হয়েছে।
The judgment and order dated 20th March 2025. My lord, I made application for ratified copy on 20th March 2025. I was notified for the state.
Just
My lord, I was notified for stamp on 29th March 2025. My lord,
আছে তোমার কাছে আছে এটা?
Past 18/2025. Thereafter, after 28 days, the copy was made ready on 29th of April 2020. So my lord, I am getting 5 days earlier, thereafter 28 days, total 33 days. And my lord, the
See,
stamp was 60 days, lordship.
No. See, date of application 24th. Just date fixed for notifying requisite stamps 29th March. Date of delivery of requisite stamp. Date on which
My lord, the application and notifying stamp there I am getting 5 days. So lordship, total 33 days. And my lord, 60 days is the statutory limit for filing preparing the appeal. So my lord, I am getting 93 days in hand.
not
So
not 93 days, not 93 days. 60 days from the date of the order. The time spent in obtaining the certified copy will be deducted from that. 60 days will be added to it. So 60 days from 24th of March. From 20th March, 60 days expires when?
On the very same date, copy is given 363 of the Code of Criminal Procedure. However, when there would be conviction, every court shall inevitably hand over a copy free of cost to the convict. Yes.
For preparing this appeal, dear my lord.
That copy is required.
33 days in my hand. So my lord.
2 months is 19th.
না 19th হবে না, ওখানে দেখো হচ্ছে মার্চ তো 20th মার্চ, তার মানে মার্চে হচ্ছে
11 মার্চে 31
হ্যাঁ 31, তার মানে 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 31, ওখানে হচ্ছে 12 দিন। হ্যাঁ এপ্রিলে হচ্ছে 30 দিন। হ্যাঁ আচ্ছা,
18th
18th
it should have been filed on 18th.
on 18th. No, 18th April. April,
In May.
18th May.
There are 33 days.
Where 33 days?
There are the delivery of stamp and the copy was made ready.
No. Oh.
Madam, application 24 March 2025.
And
Have been notified for the stamp on 29th March 2025.
no. The copy was made over you to on 29th April. So 24th of March to 24th of April. That day you will get in addition.
Oh, that means from 56 date from 29th April 2025. 56 days. Now ask your junior to calculate. 29th April 2024, the copy was made ready for delivery.
Yes.
That date.
2025 copy was made ready. Madam, can you see?
First April তো হয়েছে
Stamp.
না 24শে মার্চ থেকে
24 March is for application.
ইয়েস 24শে মার্চ থেকে
Date on which copy is ready for delivery.
হ্যাঁ 29, তাহলে 24শে মার্চ থেকে ওই তোমার হচ্ছে 18 তারিখ থেকে 18 তারিখে ইয়ে হয়ে যাচ্ছে তো
ওখানে 4 দিন লস্ট হলো।
কোন গানে
ওই 20 থেকে
না,
3 দিন।
না
3 দিন
এপ্রিল
হলো।
হচ্ছে এপ্রিল 24th মার্চ থেকে 29th এপ্রিল।
এপ্রিল, হ্যাঁ।
March.
You had
29th of March, 4 days. Thereafter, delivery of stamp first April. And the copy was made ready on 29th April.
That is what I am saying. From 24th March to 29th of April. That day you will get the benefit. 24th. Stamp report কি দিয়েছে? রিপোর্ট কি দিয়েছে?
তো ইগনোর করতে হবে আমাদের।
ডিলে তো ফটো দিচ্ছে না স্ট্যাম্প রিপোর্ট। হ্যাঁ ডিলে তো দিচ্ছে না স্ট্যাম্প রিপোর্ট।
আমার তাই নেই।
25
report you.
25 days দিল।
ও এই
ওখানে 25 দিন তো পেয়ে যাচ্ছে না।
appeal admitted considered that you're lost for.
Yes, who is your other side? What section? When there is a admission, but very well. Take down. The judge. The appeal arises out of a judgment and a judgment dated 19th March 2025 and an order of sentence dated 20th March 2025. Post of. The it appears from the report given by the additional stamp reporter that there is a delay of 25 days. However, on the invitation of the appellant, on considering the time spent in obtaining the certified copy from the date of making an application for the same, we find that more than 25 days have elapsed in between, and as such, giving benefit of the time so spent between 24th March 2025 and
29th April.
and 29th April 2025, when the certified copy was actually delivered. We ignore the, or we hold that, we hold that the appeal is within time, ignoring the report filed by the additional stamp poster. The next, এটা হচ্ছে ওই অ্যাপিলেই দাও, ঠিক আছে? The appeal is admitted. Issue notice. The appeal is admitted. The trial court records be brought before this court. The registry is directed to prepare sufficient number of paper books immediately on arrival of the trial court records. The appellant shall take necessary steps and cooperate with the department for preparation or for filing of the requisites and preparation of the requisites, process fees and cost for preparation of the, for bringing the trial court record and preparation of the paper book. the parties will have liberty to mention the appeal for being enlisted for hearing immediately after the paper books are made ready and made over to the parties. No liberty is required. Where do you get, under which provision? Tell me.
ইস্যুয়াল নোটিশ মানে ওই ওপর অ্যাডমিশনের ওখানে দেওয়া হয় ইস্যুয়াল নোটিশ এদের নোটিশ দেবে হ্যাঁ উপরে ওই যেখানে অ্যাডমিশন
অ্যাডমিশনের পর দেবো
হ্যাঁ item number 3. So why are you not appearing?
Mr. Public Prosecutor, we have not seen you for a day. The criminal appeals, death references are being taken up on called on regular basis. Unfortunate part, your name is recorded in the order, even if somebody does the matter, but you are not being found before the division bench. It is unfortunate. This is the 7th day of the circuit. For the first time, when we reacted, we find the presence of the public prosecutor. The public prosecutor has to be before the division bench. Then
I'm very much apologize, but this is a death reference, this is jail appeal.
Any matter you are not to be found. If somebody where the list shows NA, that means no one is appearing, we have to appoint advocate to legal aid. Unless you are there, how could we do that? Unfortunate that the public prosecutor is in court, but he does not come before the division bench. No apology, we take serious exception because we are finding you on the 7th day and we have been regularly noting that your name is being given in the order where you are also not appearing. This thing cannot go, at least not before this bench. Yes. No, the appeal is at the admission stage. Have you made any application for suspension of the sentence? এটা করে দাও ওই প্রবীণ।
এটা কিন্তু জানি না এই যে এখানে নিয়োগ করতে হবে
কোনটাতে বলবো
যেটা ডেট ডিফারেন্স
এটা কত?
Item number 2, my lord.
Yes.
This is the item number 3, my lord. The
Item
matter should be tagged, my lord.
Yes.
Now, whether in debt difference case any advocate is to be appointed.
This is a jail appeal, my lord, from the legal aid, my lord. And my lord, the High Court legal aid authority is there, my lord. He is also the panel. Same lawyer can do. If reference and appeal will be had together, the same lawyer can do matter. Even I have experience.
That is what we want to know. Otherwise, every day these matters are being called on and we have to adjourn it.
In those cases also, the appeal and debt reference were had together.
Yes.
So then, formal appeal is not filed, my lord. Even if there is no formal appeal, a memo of a formal appeal, even honorable division bench has enough jurisdiction to apply all the powers which this court has in case of an appeal in a year. Even a year case, while hearing a year case, my lord can pass an order for appeal.
No, that is later on. Debt reference case, none is appearing.
My lord.
So whether you forget about the any separate appeal filed by the convicted person. Debt reference, none is appearing.
From the
Yes,
Yes.
we want to ascertain
Yes.
whether any lawyer is to be here and who are the lawyer, what is the panel? From whom we can choose.
এবার দ্বিতীয় জিনিসটা হচ্ছে the appeal, if I have correctly understood you, then you say the appeal is a jail appeal and it has been filed through legal aid. So the person who is already representing the convict in the appeal may be also engaged in the death reference. That is what we want to clarify, otherwise the things will not move. Now who is appearing? You are appearing for whom?
Jail appeal, jail appeal.
And you are appearing for?
Separate, independent.
No,
Not
you are.
He's from legal panel also.
So we are appearing. Huh?
So you appear in.
I representing the state, madam.
Yes, the death reference টা করো, the learned public prosecutor. You are PP or APP?
Third, I am the judge, but not the gross learned APP.
The learned additional public prosecutor is present. He submits that. Please wait. He submits that the next item is the connected appeal. Connected appeal, and as such, connected appeal, and as such, appeal number has to be heard along with the instant death reference post. Mr. So-and-so, Bishas, Mr. Aniruddha Bishas, learned advocate, who is also an empaneled lawyer under the SLSA or DLSA, under the State Legal Services Authority, is appointed to represent the convict in the aforesaid death reference. তারপরে হচ্ছে ওই অ্যাপিলে অর্ডারটা দাও, অ্যাপিলে সিআরএ ওটাতে হচ্ছে ওই
আগেরটা দিই ডেথ রেফারেন্সের পেপার।
নো, ডেথ রেফারেন্সের পেপার বুক, অ্যাপিলের পেপার বুক দিয়ে একটা কপি হয়ে যায় ওখানে। সিআরএ তে হচ্ছে দি অ্যাপিল ইজ অ্যাডমিটেড, তারপরে হচ্ছে ইস্যু নোটিশ, ইস্যু ইউজুয়াল নোটিশ, তারপরে যেটা ছিল টিসিআর, ওই কল ফর
TCR already.
why connected appeals are there.
When there is a DR TCR or a DR mallet, TCR usual post TCR will come.
কি বললাম? Since the connected death reference is already in the list, the trial court record, in short TCR, is expected to be in this court, full stop. If not, is expected to be in court. If not, let the same be brought to this court, full stop. Requisite department is directed to requisite number of paper books. The parties will have a separate set of paper book should be prepared and supplied to the learned advocate engage to SLSA, or State Legal Service, or to represent the convict in the death reference, which has been directed to be heard along with this appeal. ঠিক আছে? So it's over.
I'm extremely sorry, my lord.
See, you have a responsibility apart from representing, because you have to also ensure that the convict gets an help from the SLS.
Grateful, great.
অ্যাপিলেট নাম দেবো একটা রেফারেন্সের ইউজ বিশ্বাস আর একটা অ্যাপিলেট স্টেটের নাম দেবো এটা কি নাম না দেওয়ার বুঝতে
APP দিতে হয় দুটোতে। APP নামটা যাবে হচ্ছে অ্যাপিলেতেও যাবে আর ডেথ রেফারেন্সেও যাবে। ডেথ রেফারেন্সে বিশ্বাসকে অ্যাপয়েন্ট করবে, আর অ্যাপিলে তো অ্যাপেলেন্ট অ্যাপিয়ার করছে, ওর নামটা দিয়ে দেবে। হ্যাঁ, আচ্ছা,
আমি আগেরটা কষ্ট দিতে বলা হলো না, ওইটা তো কথা হয়েছে, আমি করে দেবো দেখে
আচ্ছা।
Passport matter item number 4.
Yes.
In the delay of 93 days, and I there for family.
Have you served have you got a copy of the application?
Yes, copy served, my lord, but unfortunately, my lord, I have endorsed the matter to his senior, so that should be changed, my lord. I will, in due course, I will change, my lord.
Very good. It appears from the report of the additional stamp report that there is a delay of 93 days in preferring the appeal. তোমার কাছে ইয়ে আছে?
আমাদের এখানে লেখা আছে সিভিলে লিখছে, এখানে দেখছি সেখানে দেশের কপিতে লিখছে
এখানেও তো নেই।
আমি ওখানে গিয়ে বলে এসে বলছে আবার আপনাদেরটা লিখতে হবে। ওই ইয়েতে একটা সামনের একটা সাদা মতো কিছু আছে, সেই
নেই
এই যে হ্যাঁ
হ্যাঁ, কি বললো?
There from the report of the additional stamp reporter that there is a delay of 93 days in preferring that.
In preferring the appeal. After hearing the petitioner and the and the learned advocate representing the state, we find that the appellant was prevented by sufficient cause for not preferring the appeal within the scheduled period. Full stop. The delay is condo. Full stop. The application being can such and such is disposed of. Where appeal, the appeal is admitted. Issue notice, তারপর হচ্ছে এই পেপার বুক। হ্যাঁ।
Grateful, Lordship.
এই মলয় আর কি ডেথ রেফারেন্স আছে শেষের দিকে ছিল না, আগে একবার কল হলো। হ্যাঁ ওটা দেখে নিও। ইয়েস, ওই আইটেম নাম্বারটা দেখে নাও তো। ইস রেডি ফর হিয়ারিং। Are the formalities complete? Advocate ফাডভোকেট SLS এর থেকে অ্যাপয়েন্ট করা আছে, দেখে নিয়েছো? Just check. You check it out. আর করে কি লাভ?
Ethical indulgence before Lordship's rights, my lord. With serial 20 and 21 in today's list, my lord, your Lordships had been pleased to hear the matter earlier also, and your Lordships had given the date of today.
What is the matter about?
Well, that electricity subsidy. Lordships, remember these revision charges, and very short matter. Your Lordships had heard the matter extensively on the last occasion, and this was awaiting the confirmation from the licensee. And the affidavit was not notarized. That is why your Lordship said, okay, I'll hear it on the next day. Lordships could kindly take up the matter at any time, then I could give notice to the other side also, if your Lordship would kindly fix it.
Who is for your other side?
For the state. Mr. Pal for the state, my lord.
You enjoy the ambience of Jalpaiguri for one day. We don't think we will be able to. Tomorrow it will be in the first few matters.
Only praying if the Lordship would kindly give us a time to pay.
You're not selling two boat. You will come from Calcutta and you will earn your fees, do the matter, and that cannot be, Mr. Thakur. As it is, you are a very slippery customer.
Kindly, if your Lordships, if only if your Lordships both permits, I'll give notice to them.
Let us see, there may be some urgent matters. You be there, we will try to.
Grateful, deeply.
Item number 6, Lordship, Mr. Sudipta Kumar Majumdar appearing in this case. Suddenly, Lordship, when yesterday he returned back to the home, suddenly she feel the chest pain. And subsequent, thereafter he admitted to the hospital. Now he released from the hospital and bed rest, Lordship, seeking next circuit.
On the prayer of the appellant, that the senior counsel engaged on his behalf or its behalf. What about service?
Service, Lordship, so with the my knowledge is concerned, Darjeeling advocate trying to serve the copy to the advocate on record of Darjeeling, but he refused.
হ্যাঁ কি বললাম লাস্টে কি বলেছি on the that the senior counsel engaged in this matter is unavailable for health reason, either to attend the matter, either to attend court physically or through virtual mode. The appeal is urgent and shall be placed before the next available circuit subject to its convenience. It is made clear that the petitioner, it is made clear that the appellant shall comply with the direction given on 12 June 2025 for effecting service on the respondent.
Item number 7, under manual of appeal.
I beg to appeal for the state lordship.
This is for the,
Again, that same story.
দেখি ওদিন appear
Yesterday they have appeared lordship.
Yesterday they have.
you ask Mr. Pal, you ask Mr. Pal. For me, we are passing it over.
Lordship.
Item number 9, under application civil.
Item 8, my lord, item 8, I beg to appear virtually, my lord.
Item number 8, the manual application.
What is the application?
Lordship, Mr. Ray is
My lord, this is my lord, GST Group 4 GST matter, my lord. And on 11th March, my lord, Honorable Justice Harish Tandon, my lord, granted, directed to file affidavit in opposition to the respondent, and my lord granted a stay, my lord. And subsequently that stay, my lord, as per last order, there is a stay till 30th July, my lord. And till date, my lord, no affidavit in opposition filed, my lord. And last day matter called 2 days, my lord, but they did not appear on 1 day, my lord, they prayed time, my lord.
Who is for the GST authorities? Any idea?
Mr.
Mr. Subir Saha and Mr. Pradip Sarkar. Last week, my lord, they prayed time, my lord. That is why it appeared today, my lord.
We are passing it over. Ask Mr. Shah to come.
My lord.
Item number 8. Item number
Issue number 9, it is there.
Item number 9, under application C.
My lord, I appear for the respondents here,
Yes, sir.
Substitute.
Yes, sir. I have served the copy, lordship.
Yes.
When did the respondent number 2?
Yes, sir.
Respondent number 2.
When did respondent number 2 die?
12th of April 2024.
2024, sir.
And when was the application made?
Application
11th June, lordship. 11th June.
90 days er moddhe.
Lordship,
This is an application for substitution of the legal heirs of the respondent number 2 who died during the pendency of the appeal on
24, my lord, not within 90 days.
Yes.
2024. 12th of April 2024.
It was filed or died?
Died on 12th of June 2024.
12th of June, and filed when?
12th of April, sorry. Filed 11th of
11th
June
of
2025.
12 June, you will on 12 June.
This is an application of substitution of the legal year. Respondent number 2 should die during the
Pendency on 12th
April 2024.
12th April 2024. His application is made on
11th June of 2025, lordship.
11th June 2025.
My lord, here I must be candid that the better particulars were supplied by me on 14th of May 2025.
14th of May
2025, my lord.
Full stop. Although, comma, in view of the provisions of Article 120 and 121 of the Limitation Act 1963, a substitution application has to be made within 90 days from the date of the death of the concerned party. A further 60 days time period is available to make an application by praying for setting aside of the abatement. ওটা প্রথমে যেটা বললাম আমরা আর্টিকেল আর্টিকেল 120
120 and 121.
121টা তো পরে দিন ওখানে 120 কেটে দিন। Under the provisions of Order 22 Rule 10 capital A of the Code of Civil Procedure 1908, it is the duty of the pleader representing the deceased to bring the death to the notice of the court. The advocate representing respondent number 2 did not bring the death of the defendant number 2 to the notice of the court. The particulars of the legal heirs of respondent number 2 who are to be substituted was provided by the learned advocate for the respondent for the respondent number 2 since deceased only on
14th of May 2025.
14th May 2025. Considering the aforesaid facts, although this application is made, this application is made beyond the period of 150 days available under conjoint reading of articles 120 and 121 of the Limitation Act 1963. Sentence just sentence.
Considering the absence of facts, outlook upon these applications is beyond the immediate is available under conjoint reading of articles.
And there is no separate prayer for setting aside of the abatement. Yet, in the facts of the case and for the ends of justice, we condone the delay and set aside the abatement if any. And allow the substitution. The legal heirs of the deceased respondent number 2. The particulars whereof are provided in which paragraph?
Paragraph cost title 5.
In cost title only.
Give it a averment henceforth. Paragraph.
See,
You have to
can you change the cause title of the main appeal?
You are changing this yourself.
Substitute आगे change कर देते हैं। तो paragraph का था एक paragraph में cost title है।
It is in cost title.
What I mentioned in paragraph 11 just cost title number also.
Okay, as
Henceforth we don't defend.
as indicated in the cost title and referred to in paragraph 11 of the application are substituted in the place and state of the respondent number 2 by numbering them as respondents under 2 series. Let the learned advocate
Get the office is directed to them.
The
No.
the registry is directed to carry out the amendment. এটা ইয়েতে ওকে লিভ দিয়ে দিলে ও করে
My lord, what has fallen from your lordship, it's better if the leave is granted.
No. It is by the order. It remains signature of our officer.
Yes, true, my lord, the process is that, but here,
No.
very hard pressed.
আচ্ছা কি বললাম
The industry is created to carry out that.
within a period of fortnight from date after reasonable notice to the parties.
All are majors. All are majors. All are major and civilians. কানে আছে
আমি তো একটা নাম
আছে
Yes, lordship. All are major.
কি বললো আচ্ছা ওখানে সিটিং অ্যাসাইড দিয়ে অ্যাভয়েড যেখানে বলেছি না particularly in view of that the applicants are sui juris and are all major. Nothing further remains to be adjudicated in the application. Can such and such is accounted disposed of. On the amendment being carried out, let a copy of the amended memorandum of appeal be served on the learned advocate for the respondents.
Grateful. Good.
as also the added respondents or substituted respondents. Substitute respondents.
Later on, it would be degree, in the degree it would be included.
Yes, I understand.
If any error is again cocked up, then he is to come. He may be changed tomorrow by his own client.
We are very hard pressed of manpower. That is why. There's a lot.
Lordship, one indulgence. Mrs. Shah is here in item number 8, Lordship.
Lordship, may I be permitted to mention, Lordship, actually, Lordship, in item number 7, Mr. Mishra is there. I already informed Satyajit Paul. He told that his senior will argue in this matter. So he's there, he's sitting there. In item number 7. আমরা সাতশো তারপরে
Consumer matter, item number 7.
Yes.
My lord, the impugned order, my lord. The writ petition, my lord, was from against, my lord, the Polish atrocities, my lord, and the Polish overaction, my lord, the illegal arrest. My lord, writ petition was, my lord, dismissed, and
Why you have not filed any application to bring the documents such and such?
yes, my lord.
Only the order. What is the wrong in the
My
order?
lord, may, my lord, kindly, my lord, permit me to file an application, my lord, so that I could bring, my lord, those documents.
You are accused person of any one criminal case.
Lordship.
Now you are claiming that there was a police overaction on the part of the police authority
My lord,
in arresting it.
my lord,
You are arrested in connection with a criminal case.
Lordship. My lord, in order to substantiate my defense, my lord, that FIR, the suo motu FIR that has been lodged, my lord, by the Polish, my lord, need to be, my lord, substantiate before your lordship. My lord, that has not been done as because, my lord, I have inadvertently not filed any, my lord, application.
Lordship, I would like to submit the report where it is, in the report, it is clear that they have beaten the personal lordship and 2 police officers.
So
were
that was their
apprehended.
contention, my lord, in the writ petition also, my lord.
Some other allegations regarding the torture upon the custodial torture upon the petitioner, but it was also not, they couldn't establish because lordship, there is an information slip in your report regarding whether he was custodial torture or not, and it was also reflected in the information slip of the lordship, he was not tortured, and even in the medical report, it was clearly mentioned when the accused person was forwarded to the CTN court, he was medically fit first.
My lord,
And there-
History of committing cases and against himself as well as against other people. There is a list of cases which have been annexed.
In our report, lordship,
In
there
our-
are so many allegations regarding they are the habitual offender, lordship, in the locality, and so many mass petition was filed against the writ petition and their family members, lordship.
my lord, in order to substantiate my defense, my lord, I have to file, my lord, an application, my lord. Kindly give me a liberty, my lord.
And because of
Was
this,
that-
he did not file any copy in his support, lordship. Because
It is
in the month of
absolutely,
April-
my lord, a wrong acquisition, my lord.
In the month of.
Lord, give me a liberty, my lord, so that I could file an application,
You
my
are a
lord.
person against whom numbers of cases are there.
Yes, lordship.
They have
My lord,
Now you are-
permit me, my lord,
you
to
are-
file an
you are
application,
claiming
my lord, so that I could
police
substantiate
atrocities.
precisely, my lord, whatever, my lord, what kind of, my lord, atrocities I have been encountered with on that, my lord, night. And a suo motu FIR has been lost, my lord. I have been, my lord, mercilessly beaten, my lord, brought to the lockup. Inside the lockup, I have been beaten, my lord. There was a direction by the learned court below before the trial court where I have been, my lord, produced, my lord, conduct a medical examination. A CT scan was directed. Nothing has been done, my lord.
Lordship also well known that.
My lord, inadvertently, I have not filed an application, my lord. Kindly give me a liberty so that I could substantiate, my lord.
Lordship also well known that when a person was forwarded to the CGL, he has
Called or application is to be filed. Okay, file an application, what can be done? Application file করতে চাইছি ভারত application file করতে চাইছি item number 7.
7, Lordship.
7. Application file করতে চাইছি election with them. Okay, Mr. Mishra Lanet advocate representing the appellant pressed for an accommodation to take appropriate steps. He pressed for leave to file an application to bring certain relevant documents on record. Stopped. The learned advocate, Mrs. Bose, learned advocate representing the state, to propose such pair. Because it include thereof, place the matter before the next available circuit bench. The petitioner is at liberty to prepare appropriate application in the meantime with the advance copy of the same.
Lordship, I may be corrected. We have opposed this. We are opposing this. It has been mentioned by you.
Lordship allow. Lordship allow.
Lordship, it is in their view, on the first date of appearance in this case, they have said they have withdrawn themselves from filing any application. It is submitted by them itself. On the first date of this.
See, end of the day, the appeal cannot be rejected.
Yes.
See, take the bull by the horn, face the appeal. Why? Don't go by the technicalities.
So, এটা লিখতে হবে না, ওনার ইয়েটা লিখতে হবে না, oppose the pair for bail, ওটা লিখতে হবে।
ওরা ওখানে কি বললো, the respondent as
Place the matter into the next circuit, the applicant circuit. The petitioner is at liberty to prepare an application. In the meantime, you can advance copy of the same to Mr.
application for condonation of delay.
No, appropriate order কিছুই নেই, শুধু মেমোটা আছে আর
Lordship, they only attach the memo of appeal.
দরকারই নেই।
Knowing everything, Lordship.
The memo,
রিপিটিশনটা কল ফর করে নিচ্ছে।
কোনটা?
রিপিটিশনটা
ইনফর্মাল পেপার বুক করে নেবে।
There was a direction for filing of informal paper books also. That has also been now filed.
Oh, there was a
Yes,
direction.
Lordship, there was a direction in
কি
earlier.
অর্ডারটা আছে দেখি?
They did not comply.
Yes, what is the order in Pune? This.
Lordship, on 8/4/2025.
Order dated 29th of January.
এটা না পেপার বুক
Impugned order, ঠিক আছে, impugned order.
ইনকো নটারি এগেইনস্ট সিটিজেন বুকের ডাইরেকশনটা বল হ্যাঁ এটা বলা হয়েছে ওটা কোনো বলছিস
What is your grounds of objection? Yes.
My repetition was the sole contention of the repetition was that the suo motu FIR that has been lost, following which the petitioner was, the appellant was arrested. He was subjected to police
Torture.
And the entire prosecution case is a unconfident afterthought. The situation.
The difficulty is that
that cannot be
if
examined at this stage.
read petition কি করে ওটা ইয়ে করে?
That is question of fact. You know, Mr.
No, whatever may be, no.
Custodial torture. There was a direction by the learned court below where the petitioner was produced immediately after his arrest. For medical examination, a CT scan was directed by the learned trial court to conduct. Nothing has been done, He was remained in custody without having proper check-up or medical examination. Only in order to brush aside under the carpet the custodial torture that has been perpetrated by the investigating agency, by the police
No. What are the charges?
Charges under
You obstructed the police authority from executing the arrest or executing the arrest. Thereafter, the incident occurred. There was a fighting.
Yes, and two police personnel already admitted due to this incident, Lordship. And we have all the documents, Lordship. He has medically fit. That documents also we have, Lordship.
The extent they have aggravated the crime in the suo motu FIR, nothing has been happened.
So police went to arrest you in execution, warrant of arrest or anything?
No, absolutely not. The situation is completely different.
So police
The story is completely different.
Police went there to discharge their duties.
No, my lord. Kindly, hear me out for a second.
Yes.
On that.
You say the background of the incident.
রিট পিটিশনেই বলা আছে, রিট পিটিশনটা চেয়ে নাও তো।
হ্যাঁ, সেটাও রিট পিটিশন তো কল for.
Was affidavits filed?
No, Lordship. Lordship, I would like to submit the report also.
Copy of the petition.
So everything is there in the report, Lordship. All the documentaries.
That is their concocted report, madam. They have prepared.
Hospital documents is this possible? The documents of the hospital
Just a minute, just a minute.
is manufactured. Documents of the court has been manufactured. Is this possible, Lordship? কত নাম্বার? হচ্ছে 23 আমার নামটা দিয়েছি।
No safeguard has been.
Just a minute. করতে পারবেন একবার একটা কোঅর্ডিনেট বেঞ্চ কিন্তু অ্যাপিল টু বি হার্ড আউট yes take down
Direction was given to file informal paper book. You have not complied with that direction in the month of April.
Yes.
by an
With a fortnight.
no, by an order dated April থেকে বলা আছে by an order dated this appeal arises out of an order judgment and order dated 29 January 2025 whereby the appellant's writ petition being WPA 72 of 2025 was dismissed by the learned single judge of this court. By an order dated 8th April 2025, a coordinate bench after prima facie consideration of the appeal found that there is no scope of passing an interim order. The appeal is required to be heard. And as such, directed preparation of informal paper book by the appellant within a fortnight from the date. Within a fortnight from that date. That is by 22nd April 2025. No paper book has been filed on 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 13th May 2025, the time to file paper book was extended upon payment of cost assessed at ₹5,000 payable to the Jalpaiguri Circuit Bench High Court Legal Services Authority. No cost has yet been paid. Post on. When the matter was called on 9 June 2025, the learned advocate, Mr. Deboshi Dhar, who represented the appellant, submitted that he has given no objection and is no more appearing in this matter. On 16 June 2025, Mr. Satyajit Pal, learned advocate, appeared and submitted that he has the instruction to appear on behalf of the appellant. Where is your Vakalatnama?
Today, Mr. Mishra. I will submit it.
Today, Mr. Swanso, Mr. Mishra, puro namta niye na, appears and submit that he will be representing the appellant and will be filing the Vakalatnama in within কালকে ডেট দিয়ে পোস্ট by post by 18th. The conduct of the appellant is regretted. Despite opportunities being given, the appellant has not availed the same for proceeding with the appeal. With the appeal. The informal paper book has not been prepared. The cost has been not deposited. In the aforesaid facts and circumstances, we are not inclined to keep this appeal pending any further. The appeal stands dismissed. There shall be no order as to cause. না স্টেট থেকে কিসের রিপোর্ট দিয়েছে? না ও রিপোর্ট তো কেউ চায়নি, হঠাৎ করে স্টেট দিচ্ছে কেন রিপোর্ট? প্রথম নিয়েই আপনি বিপদে পড়বেন। ওখানে কি বললাম ওইখানে লাস্টে বললাম দেখো in the aforesaid facts and circumstances, it is explicit that the appellant is not interested to prosecute the appeal and is only delaying the hearing of the same. The appeal stands dismissed. নামটা নিয়েছো ওই অ্যাডভোকেটের? সে তো পালিয়ে গেল।
মিশ্র কি সুভাষিস
তার এইটুকুনি ভদ্রতা নেই যে সে অর্ডার শেষ হওয়া অব্দি দাঁড়াবে। ঠিক আছে।
Passport matter, item number 8 under application. My lord, I beg to appear virtually, my lord. My learned advocate on record appearing in court, my lord. My lord, here, first order passed on 11th March, my lord. There is stay, my lord. There is direction for exchange of affidavit, my lord. Till date, no affidavit original filed, and my lord, stay extended 3 times, my lord.
Under compelling circumstances, my lord, I am respectfully paying to extend the time, my lord, because my junior, after returning from his uncle's funeral, he is attacked with this pneumonia, and his residence is in Shiliguri. So I am really in this embarrassing situation.
My lord, interim order may be extended, my lord. There is interim order, my lord, till 30th July or until further order, my lord. Last order dated 13th May.
Despite several extensions being obtained.
Yes, my lord.
The despite several extensions being obtained on behalf of state, no affidavit in opposition has yet been filed. The matter has been adjourned on 21st April 2023.
25, my lord.
As also 21/4/2025. As also on 12th May 2025.
13th May, my lord.
13th May, sorry. Even today, the state seeks for extension of time to file the affidavit of resolution on the ground that the learned advocate engaged to represent the state is unwell. Full stop. Although the conduct of the state respondents do not inspire us to extend the time, yet for the ends of justice, the time to file affidavit in opposition is peremptorily extended till till 27th June 2025. Reply, if any, by 11th July. Let this matter appear before the circuit immediately after available immediately after 11th July. It is made clear that no further extension of time to file affidavit in opposition shall be granted, and the matter will be heard without the affidavit if the same is not filed within the extended period of time. The interim order, which is till 30th July, which is still in subsistence till 30th July, is extended till 31st August or until further orders, whichever is earlier.
My lord, liberty to mention, my lord.
Who has stopped you from mentioning?
My lord, I'm grateful.
কি বলবো, অর্ডারটাও শোনে না, বলে দিলাম যে নেক্সট অ্যাভেলেবল প্লেস বিফোর দি নেক্সট অ্যাভেলেবল সার্কিট, তারপর বলে লিবার্টি টু।
No, sorry, my lord, some technical glitch, my lord, in the microphone, my lord.
Item number 10.
I'm grateful, my lord, I'm grateful.
Item number 10, under application C.
For the respondent number 15 and 16, Lordship.
Respondent number
15 and 16.
15 and 16. Who is for the appellate?
I'm for the appellant.
Yes.
Respondent
Lordship, as per the direction of your lordship, I have served
upon the all the respondent lordship.
15 lordship already expired on 1st December 23 lordship, and the four are legal here.
Supply. It is submitted. Now, you are appearing for whom?
Respondent number 2, my lord.
You are appearing for? Yeah, 15 and 16. You are appearing for? Pursuant to the direction given on 9th June 2025 for serving the respondents, the respondent number 2, 15 and 16 are represented. It is submitted on behalf of, it is submitted by the learned advocate representing the respondent number 15 that the said respondent has expired on
1st December 2023.
or expired on 1st December 2023. Yes, appeal করে ফাইল হয়েছে।
23rd April 2024.
No. Are you sure? Have you got a copy of the death certificate? Yes. Just a minute, just a minute. Who is the whose death certificate did you hand over to us?
15 lordship. 15, the name Nataru Das is the nickname. He's the Nataru Das. This is the
Jogesh Das.
So he is Jogesh Das. Nataru Das is the nickname.
That is what I was checking.
Nataru Das and Tataru Das, two brothers. Nataru Das is Jogesh Das to die.
It is submitted. The death certificate is placed before the court in support of the same. On a perusal of the death certificate, it appears that the same is in respect of one Jogesh Das. On a query from court, it is submitted by the learned advocate representing the respondent number 15 that
Nickname of Jogesh.
that the said respondent had been impleaded in the appeal by his nickname Nataru Das full stop. এবারে ট্রায়াল কোর্টের সামনে বললো না। This is how things are unnecessary complication.
Oh, my lord, the filing has been, my lord, made of the instant appeal after the date of.
That I have noticed, madam. But did you say before the trial court, the appeal arises out of the trial court proceedings? Did you say before trial court, Nataru and Tataru are the nicknames? You never said so.
They received the summons with that name. From the trial court.
My lord, yes, lordship, must be lordship.
কি বললাম?
Have you filed Mokarodnama?
Yes.
With the memo of.
তো ছেড়ে দাও a copy of the death certificate of Jogeddas is made over. Nah, it appears from the record that the appeal has been filed on 23rd April 2024. That is subsequent to the death of Jogesh Das, who, according to the learned advocate representing the respondent number 15, is the said respondent. Poster. Since the death of one of the respondents have been brought to the notice of the court, in terms of the provisions of Order 22, Rule 10, Capital A of the Code of Civil Procedure 1908, the appellant is granted liberty to cross-check whether Nataru Das and Jogesh Das is one and the same person and take appropriate steps in the appeal. Let this matter be placed before the next circuit bench, subject to its continuance.
Grateful.
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 The gate রেখে দাও. You hand over a copy of the death certificate. Hand over a copy of the death certificate.
Item number 11 under application 0.
Yes, Lordship, I am honoring of the appeal and Lordship.
Yes.
In this matter, I led by Mr. Ramcharan Gochari, Lordship. Well, Lordship, I heard he heard the respondent, but not effective, Lordship. The affidavit of service, Lordship.
Why not effective?
Service returned, Lordship, to the center.
Endorsement?
Back to return.
With the endorsement?
Door lock, Lordship.
Door lock.
ওই নিচের কোটের ইয়েকে সাফ করে দিতে বলো আর কি করবে। It is submitted by the appellant that it is submitted by the appellant that the service on the respondents could not be effected in terms of the order dated 20th May 2025, 20th May 2025, as the articles dispatched came back with the endorsement, a postal endorsement, door locked, full stop. Which is the police station?
Siliguri.
Siliguri police station. Are you sure?
Yes, Lord.
Hmm.
Post and pay Siliguri.
The petitioner the appellant is directed to effect service to the, on the respondents to the local police station by furnishing sufficient number of copy of the memorandum of appeal and the and any connected application.
Yes, Lordship.
And the connected application.
Conversion of delay and next application.
And the connected applications filed therein. Full stop. Let this matter appear before the next circuit bench subject to its compliance. স্টেট বলছে অ্যাপিলেন্ট স্টেট বলছে সার্ভিস করতে পারি না, মুশকিল বলো।
Item number 12, under tribunal appeals. Item number 12, I'm praying for a short pass over.
On the last occasion, your lordships have directed me to obtain information as to whether there was delivery of the confirmation of delivery of the
Review application.
Review order. Order of
If I correctly remember, Mr. Ghosh submitted that a review application was filed.
Yes, my lord.
But the review application was not disposed of. But later on, in connection with the subsequent steps, the appellant came to know that its review application has been dismissed.
Yes.
Now, by an order of a particular case. Now, it was submitted that no copy of the order was served on.
Dismissal order, my lord.
Yes,
my lord, I obtained information from the concerned department. My lord, what I have found is that though there is a letter addressed to the petitioner, with a memo number 602 dated 27/8/2015, communicating such a dismissal, but the details of whether the same has been received by the respondent, by the appellant's hearing is not.
No point. Full stop.
This is the communication that has been received pursuant to the directions of your lordships. My lord, it has been stated in last line. Details of service of such order could not be traced through available records in this office.
Admittedly, a review application was filed by the appellant challenging the against the order dated, which was the order under review.
My lord, that's
30th June 2015.
30th June 2015, full stop. On the last occasion, it was submitted by the revenue bracketed respondents that the review application, the order. It was submitted by the revenue bracket by the state GST authority. State GST by the.
No, this is not GST. Basically, this is VAT and sales tax.
The
state tax
state tax authorities. Respondents that
sales tax.
State sales tax authorities bracketed respondent that the review application, the order rejecting the review had been served on the appellant, which was disputed by the appellant. Full stop. In such situation, the state sales tax authorities were directed to produce the documents in support of service of the order dated
27th August 2015.
27th August 2015 to have been by which the review application was dismissed to have been communicated to the appellants. Full stop. The state sales tax authorities have placed before this court a note prepared by the sales tax officer Shiliguri charge, Shiliguri, wherefrom it does not appear that the order dated 27th August 2015 was served on the appellant's system. In the aforesaid facts and circumstances, the order dated 27th August 2015 is set aside and or quashed, and the review application is directed to be heard on merits by affording the appellant, bracketed review applicant, a reasonable opportunity of hearing.
Yes, sir. Only one indulgence, one of the proper fees had not been paid. Only part of the fees have been paid.
Rupees 200 according to our records have been paid. Any
It is
deficit
rupees
fee,
400.
well, any deficit fee that is.
The review applicant shall deposit
The deficit
the
fees.
court fees,
Deficit for-
Deficit statutory fees.
Statutory fees.
statutory fees, if any.
Probably-
The statutory, the deficit statutory fees, if any, within a fortnight from date.
Great.
Good.
আচ্ছা,
Probably
ওপরে একটু উপরে চলে যাও তো, একদম প্রথম দিকে চলে যাও। হ্যাঁ,
Admittedly, a review application was filed by the applicant against the order dated 30th June 2015. On the last notification, it was.
তা ওখানে দাও, the said review application according to হচ্ছে the state sales tax authorities, bracketed respondent, was dismissed on 27th August 2015
On account of non-payment of.
on account of non-payment of the
Statutory fees.
statutory fees. Full stop. It was submitted by the appellant that to their knowledge, that to its knowledge, appellant, to its knowledge, the statutory fees of rupees 2,000
200 was.
of rupees 200 had been paid, which according to the state sales tax authorities is rupees 400.
400.
Since the review was rejected only on the ground of non-payment of statutory fees, তারপরে হচ্ছে তারপরে কি ছিল বলে সেন্টেন্সটা
On the last one, it was.
কি বললাম? We inquired as to whether the order rejecting the review application was served on the appellant. তারপরে ওইটা দাও,
The last one, it was submitted.
তারপরে যা আছে।
Probably, Millard, subject to correction, Millard would also be pleased to set aside the order of the tribunal.
Yes.
Which Millard has not.
Perhaps to set aside.
Yes.
The tribunal's
of the
order
tribunal
has
is
to be
clear.
set aside, against which we came up.
Challenging the dismissal of the review, they had gone up before the tribunal, which dismissed their application.
আচ্ছা, ওখানে ওখানে হচ্ছে তারপরে না না ওই যেখানে আমি ওই যেটা ছিলাম রাইডারটা দিলাম না ওইখানে একটু লিখে দাও তো
পেজ নাম্বার নেই আমার তো
ইমপ্লুন রডেরটা তো
22
24
11th March 2020. The original
11
certificate.
March 2024
24.
in RN
RN 294 of 2022.
RN.
জাস্ট হ্যাঁ আচ্ছা চ্যালেঞ্জিং দি অর্ডার of review, the appellants preferred an appeal before the tribunal being কি RN শুধু
RN 294 of 2000.
না না আগে একটা কিছু আছে ওদের
না RN number একটা নাম কেস নাম্বার
being case number RN-294 of 2022. The appeal was rejected by mechanically upholding the order, rejecting the review without discussing the matter of, without either discussing the matter on merit or giving independent reasons. তারপরে হচ্ছে হ্যাঁ 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 India aforesaid facts and circumstances. না, India aforesaid facts and circumstances, the order. না না এটা অ্যাপিলের অর্ডারটা হচ্ছে প্রিফার্ড অ্যান্ড অ্যাপিল বলেছি তো কেস নাম্বার হ্যাঁ
11/3/2024
which was কি বলেছি ওখানে সেন্টেন্সটা
Challenging order of review, the applicant preferred an appeal before the trial court being tribunal. Being RN number 294. The appellant was rejected by mechanically
was rejected by an order dated was rejected mechanically by an order dated
11th March 2020.
11th March 2024, which is the subject matter of challenge in this appeal.
Writ petition.
In this writ petition. In this judicial review court, in this judicial review. ঠিক আছে তারপরে হচ্ছে order dated is order dated order
24 is set aside.
Order dated 11th March 2024 is set aside. The and quashed. The order dated 27th যেটা
27th August 2015.
is also set aside and quashed. তারপরে যেটা আছে
Extremely grateful.
এটা রেকর্ডে নেওয়া হয়েছে কিনা দেখুন রেকর্ডে নেওয়া হলো ওই যে চিঠিটা নাকি নোটটা
ওটা নিয়ে নিও রেকর্ডে নিও
রেকর্ড
Grateful.
Grateful.
Item number 30, under tribunal appeals.
Let's say appear for the petitioner lordship. Item number 13 lordship.
Yes.
Let's say I am challenging the order passed by the learned administrative tribunal lordship. Lordship will find page 154 of my writ application. Lordship.
Who is
This
for
is
the
an-
respondent?
Lordship, very present.
Lordship, this is an application for subject matter of this requisition is lordship compassionate appointment lordship. Lordship will find page 154 the impugned order of the learned West Bengal administrative tribunal lordship, whereby my application was rejected on the ground of delay lordship. But
Yes.
if you lordship, in the case of the petitioner is that lordship, father of the petitioner lordship who was and group B employee of the Krishi Somik under the respondent authority. While he was in service lordship, he expired lordship on 4th October 2022 lordship. Thereafter lordship, on 13 December 2022 lordship, mother of the petitioner made an application in favor of the present petitioner to appoint.
Yes.
Year of the 30th August 2007, lordship, present petitioner lordship make an application along with pro forma application before the respondent authority praying for compassion.
When?
14/12/2020. 13/12/2020.
Yes. What is the wrong then? Say,
On 3rd August 2000, pass an order
This application
directing lordship
is before the tribunal. This is that.
Yes.
directing the respondent authority lordship to consider my application and pass a reason order lordship. But they did not took any appropriate steps lordship. And having no other alternative lordship, again lordship, petitioner filed an application before the West Bengal Administrative Tribunal. Lordship will find the order that is on 12 July 2016 appearing as page 63. Thereafter lordship, in terms of that order lordship, on 12 July 2016, the respondent authority lordship on 6 June 2017 passed a reasoned order, thereby rejected the claim of the petitioner on the ground of delay lordship. Thereafter lordship filed the original application being 100.
Since how many years your father has passed away?
Lordship, 2002 lordship, father of the petitioner has expired lordship. 2002.
23 years.
But lordship, we have filed the application. Mother has filed the application for compassionate appointment immediately in the year of 2002. Thereafter, lordship, present petitioner made an application in the year of 2007.
Tribunal observed, Mr. Ubaidullah, tribunal observed that you could not produce the copy of any application which was submitted according to you prior to 30th August 2007. Where is that application?
Lordship, kindly see lordship, page 152A. This is the first application by the mother to the respondent authority lordship in favor of the petitioner.
Take down.
This has not been considered.
Take down.
And lordship, honorable division bench lordship, kindly find page 142. This lordship, 13 December 2002 lordship, this application should be considered in the earlier coordinate bench order lordship. Lordship will find 142 earlier coordinate bench order lordship. The relevant portion is page 144 in the bottom portion lordship.
Just a minute.
Lordship.
This judicial review arises out of an order dated 21st March 2025, passed by the West Bengal Administrative Tribunal in OA 1006 of 2017, by which the applicant's application inter alia for a direction upon the respondent authorities to give compassionate appointment to the applicant was rejected. It is the case of the appellant, and it is the case of the applicant that the applicant's father, while serving while serving the serving the Department of Agriculture, Government of West Bengal, died in harness on 4th October 2002. 4th October 2002. Yes, petitioner father. Yes, petitioner's father. The applicant's father.
Oh. Yes, that has been recorded. Oh.
The petitioner states that the petitioner's mother made an application on 13th December 2002 for granting compassionate appointment to the petitioner. Full stop. The mother, your mother had prayed for.
Yes.
কি বললাম? কি বললাম?
Made an application in
Too hard. Full stop. Subsequently, the applicant made an application for appointment, for granting him compassionate appointment on 30th August 2007. Post up.
After 5 years.
My lord, mother made an application, lordship, in the year of 2002 in favor of the petitioner, lordship. If you lordship kindly see, lordship, page 152.
That you could not be able to prove.
খালি ভুলভাল বলে যাচ্ছে।
Earlier division bench stated that
আগেরটাই ঠিক ছিল।
But lordship, we have filed a review application, lordship, in terms of the affidavit passed by the honorable coordinate bench, lordship. But in that affidavit, lordship, the respondent author did not file any opposition, lordship.
Very well, very well.
Lordship, kindly.
Very well.
It's that the petition is not made an application on 13th December 2002 for listing consulting the appointment to pass.
Compulsion appointment in favor of the petitioner. Post of.
Subsequent notice that the applicant made an application for granting the compassionate appointment on 30th August 2007.
2007, full stop. The matter thereafter has been traveling from one forum to the other, full stop. After the authority, after the respondent authorities had rejected the petitioner's application for compassionate appointment on the ground of delay, full stop. The records reveal that which is your first application before the tribunal?
The first application, Lordship, in the year of 2011, Lordship. Lordship, kindly see the order. That is page 56A of my petition, Lordship. Order dated 3rd August 2011, Lordship.
Page 50?
6A. 56 capital A, Lordship. In the bottom portion, Lordship. Having heard the learned advocate of the for the application and for perusal of the materials record, Lordship.
2011.
Yes.
8, 2011. Page 56A.
Challenging such refusal order,
Yes, sir.
challenging the inaction on the part of the respondent authorities, the petitioner filed an original application before the West Bengal Administrative Tribunal, being OA 415 of 2011, which was disposed of by an order dated 3rd August 2011, directing the Deputy Director of the Agricultural (ADMN) Department of Agriculture to consider the application, to consider the petitioner's, the applicant's application together with all annexures. By and dispose of the same by passing a speaking and reasoned order. Full stop. Where is the reasoned order?
Thereafter, Lordship, no reason.
They passed it.
They have simply said that file has not been traced.
Oh, 1 minute. Whether they passed any reason order, court wants to know. No. So they didn't file any complaint.
Find the second original application. OA number
It is the further case of the applicant that despite such order, no reasoned order was passed by the concerned respondent authority. As a consequence whereof, the petitioner had to file a further application before the administrative tribunal, being
OA 643 of 2006.
OA
643. 643 of 2016, which was disposed of.
যা এনেক্সে দিয়েছে কোনো অবজেক্টই পড়া যাচ্ছে
পরের পাতায় টাইপ করে দিয়েছে।
OA 415 of 2000. Oh,
643
which page
62A.
Page number 62. Order 62 is the type. So that's
OA number 643.
of 2006.
But there is also an OA I find of 2011.
Yes, that is the first way.
First way.
Original and first.
ওরা contempt করে দেয়।
The first way lordship in the year of 2011 lordship, that has
Very
not
good.
been considered in my application lordship.
It was not considered.
Very
But
well.
after passing of the first order lordship,
Yes.
no reason order was passed, that's
Oh.
the second way.
643 of 2016, which was disposed of by an order dated 12 July 2016, directing
Principal Secretary.
directing the
Principal Secretary to the Government of West Bengal, Department of Agriculture to take a decision in respect of the.
লিখে ওটা
To take a decision in respect of the pair, in respect of the petitioner pair for compassionate appointment within the time specified therein.
Then what happened?
Content application.
Lordship, thereafter lordship,
Where?
lordship will file page 70. 70, they have rejected my application lordship. The departmental order dated 6 June 2017, lordship will find page 70 lordship.
According to that order, this order was.
70A.
The principal secretary, no, the additional chief secretary the government of West Bengal, Department of this is Law and Vigilance.
Agriculture, law and vigilance.
Department of Agriculture, Law and Vigilance branch passed a reasoned order on 6 June 2017, challenging that order What happened? Challenging this order, you filed?
Original application, lordship will find the order pay at page 109, lordship.
OA 1006.
Lordship.
You're all annexure are illegible.
Lordship, I'm extremely sorry, lordship, because
OA 1006.
Filed an origin challenging the said reasoned order. The petitioner filed another original application being OA 1066 of 2017.
1006.
1006 of 2017. The said application was disposed of by an order dated 18 July 2019.
Against that order, lordship.
8 July.
8 July and 18 July.
8 July, lordship.
8 July,
lordship.
2019.
Affirming the decision of the additional
By-
chief secretary.
By which the decision of the additional chief secretary was affirmed. Was affirmed. Challenging what?
Lordship, against that order, lordship, we have filed a review application before the learned West Bengal Administrative Tribunal, Lordship will find the order at page 134 of the
One?
petition, Lordship. 134, Lordship, 134.
134.
Lordship, order dated, Lordship, 14 February 2020, Lordship.
Against the said order, the petitioner preferred a review application being RA number 9 of 2019. Full stop. This review application was
14th February 2020.
was rejected
2020.
was rejected by an order dated 14th February 2020. Full stop. Challenging the original order.
So both the order was challenged under WPST 1 of 2011, Lordship. Lordship will find page 142.
Challenging the orders dated
8 July 2019 and 44 February 2020.
The petitioner, the applicant filed a judicial review before this court. Full stop. Being judicial review before this court being WPST 1 of 2021. Full stop. The said application was dismissed. Now, the said writ petition. The said writ petition was allowed.
By setting aside the earlier order, Lordship.
যদি স্যাটিসফাই করতে পারে যে 30 ডিসেম্বর 2002 এ
কি বললাম allowed on the ground that the petitioner was allowed that that in the event the petitioner could satisfy that the application was made on 30th December 2002, which was within few months from the death of the employee, and a further request was made on 30th August 2007. The learned tribunal just the learned tribunal shall permit the petitioner. না এটা হলো না তো কি বললাম
The said petition was allowed on the ground that
না the said writ petition was allowed. Full stop. The principal ground on which the said writ petition was allowed that the tribunal did not take into account the application said to have been made on 2002 যেটা হলো
30th December
which was followed by a further request made on 30th August 2007. The learned tribunal was therefore directed to permit the petitioner to place on record the letter dated 30th December 2002 by way of an affidavit, an opportunity was also given to the state respondents to file a rejoinder thereto. Full stop. the said application being OA number 1006 on having been revived has been disposed of and has been dismissed by an order dated 21st March 2025, which is the subject matter of challenge in this writ petition. Full stop. On a perusal of the said order, it is evident that the applicant could not produce the application, produce a copy of the application.
Submitted 13, it is not. It is not 38.
Actually, it should be 30.
This was 13 December, Lordship. There's a typographical error in the order, Lordship.
The order is 30.
13 December, Lordship.
Application is dated 30.
13th,
However, in the order,
13th December,
2022.
order is very wrong.
2002, Lordship.
So what is page 152?
But Lordship, they have not filed any rejoinder before the learned state administrative tribunal, Lordship.
very well, very well, very well. We
Lordship,
have
Lordship.
heard you. কি বললাম?
That the applicant could not produce a copy of that.
Dated dated 13th December 2002, but had produced a plain paper letter by a memo dated 150 by a memo bearing number 150 dated 14 December 2022 on a query from court. It is submitted by the petitioner and not disputed by the respondents that the same has been wrongly recorded as 14 December 2022 instead of December 2022, full stop. The endorsement part change. And endorsement.
You recommended and forwarded to ATO Shithal for taking necessary action. এটা কে করেছিল সেটা বলে যাচ্ছে। It was noted by the tribunal.
কি বললাম?
Query from court submitted by the petitioner and now disputed by the respondent that the same has been wrongly recorded as 14th December 2020.
Instead of 14 December 2020. 2002, full stop. The petitioner has referred to Annexure K at page 152 of the writ petition. In this regard, and as relied upon an endorsement at the left hand bottom corner of the said page to memo number 150, and have also shown the endorsement below the same, by which it appears that কি বললাম, by which that the same was recommended and forwarded to the ADO Sitai for taking necessary action. Full stop. Whereas the tribunal dealt with this,
Lordship, tribunal dealt with Lordship.
Internal page. Internal page.
Lordship, page 154, Lordship.
Internal page.
Second paragraph.
Mr. Agarwal, Learned Counsel submitted.
There is no observation, only recording my submission.
হ্যাঁ কি বললাম, হ্যাঁ হ্যাঁ
at the left and bottom corner of the said page. And also shown the endorsement below, the same by the, it appears that the same was recommended and forwarded.
That's similar, that the application said to have been made by the petitioner's mother. তারপরে ওটা was
Recommended for the ABS for
and was now was recommended.
recommended forwarded to the ABS for taking necessary action.
Full stop. The tribunal has taken note of this document, but has not dealt with the same. Although this court by its order dated
By order stated, please, page number, by your order dated 22nd December 2021.
had specifically directed the tribunal to take note of such application. Full stop. The endorsement below memo 150 dated 14 December 2002 clearly suggests, prima facie suggests that such an application was made, which was forwarded to the additional director of agriculture. Full stop. Full form of ADO is Additional Director of Agriculture.
It is actually additional director of agriculture. It is written as ADA,
Oh,
but it should be ADA.
ADA.
It is ADA. Sure.
It also appears from the said document that the applicant's mother had prayed for compassionate appointment for the petitioner. Poster. In the aforesaid facts and circumstances, we find that the tribunal has not acted in terms of the direction given by this court, vide order dated 22nd December 2021, passed in WPST 1 of 2021. Although the whole basis of compassionate appointment is to give immediate relief to the bereaved family to tide over the financial crisis. Suffered due to the loss of the sole bread earner, gets frustrated on there being inordinate delay. But the petitioner cannot be blamed for the same, as the petitioner upon finding that the petitioner applicant cannot be blamed from the same, as the applicant on finding that that his mother's application dated 13th December 2002 having not been considered, had filed a request letter on his behalf to the respondent authorities. The subsequent events have been the events which occurred subsequent thereto have been narrated here in above. Full stop. It is true that successive petitions to achieve a favorable order in favor of a litigant is an abuse of process as held in as held in the judgment reported in 2006, 3 SCC 674. But the same principles cannot be applied in this case. In the aforesaid facts and circumstances, the order passed by the West Bengal Administrative Tribunal dated 21st March 2025 in OA 1006 of 2017 is set aside. The tribunal is directed to consider the document as in a document being annexure K at page 152 of this writ petition as discussed herein above to decide the petition, decide the applicant's claim for compassionate appointment.
Great, Lordship.
Nothing further remains to be adjudicated.
Your Lordship, may I permit to file the affidavit of service on behalf of the
ঠিক আছে, nothing further to add, accordingly disposed of. Opore affidavit of service filed in court today is taken on record.
Much obliged. One here.
Number 14, and the unanimous appeal hearing.
My lord, I'm appearing for the petition, Lordship. It's a ready matter, Lordship, can take it up.
Who is for the respondent?
My lord, Ms. Sarkar is appearing, I guess. She was here in the court.
Very well, passed over. Passed over. Probably we cannot
My lord.
come back today. Passed over.
My lord. My lord, can it be taken up? Can it be fixed on day after tomorrow, Lordship? If Lordship so permits me. My lord, my learned friend is there.
Very well, come. We cannot finish up the hearing within a half an hour.
My lord, it will be. It's not a very big matter. Very short issue in hand. If
Tomorrow,
Lordship kindly
come.
permits me.
Tomorrow, no difficulty tomorrow.
Day after tomorrow, my lord, because tomorrow I'm scheduled to appear before the Honorable Delhi High Court, Lord. The only difficulty. Day after tomorrow, my lord, if Lordship
Very well.
kindly permits me. Madam, I'm so grateful.
Item number 15. Item number 15.
Lordship,
Yes.
Lordship, আমি পিটিশনার ইন পার্সনের ওয়াইফ বলছি, ওনার শরীর অসুস্থ থাকবার জন্য একটা নেক সার্কিট করবার আবেদন করছি কোর্টের কাছে।
আচ্ছা, the petitioner,
In-person
আপনার উকিল বাবু আছে?
আমার হাজবেন্ড নিজেই উকিল, কিন্তু আনপ্র্যাকটিশিয়ান লয়ার উনি। ওনার ম্যাটারটা লয়ার নিয়ে
ফাইল করেছে আপনি কার হয়ে অ্যাপিয়ার, মানে কার হয়ে বলছে?
ওয়াইফ হয়ে বলছি, নেক সার্কিটের আবেদন করছি,
না
কারণ
না, আপনি নেক্সট সার্কিটে কার হয়ে?
আমি আমার পিটিশনারের হয়ে। হাজবেন্ড।
This appeal has been filed by the petitioner in person, poster. It is submitted by the wife of the appellant, public writ petitioner, that he is unwell, and as such is not, and as such is not in a position to conduct the case by either physically appearing before the court or through virtual mode. A further in the aforesaid facts and circumstances, this matter is adjourned and shall be placed before the next circuit bench, subject to its convenience.
Well, I was late, my lord. No, my lord. The matter was been handed over to CID. CID has taken over, my lord. My lord, sealed envelope, the report has been filed. Kindly kept to the letter.
What is the matter?
Matters, my lord, to some extent has a far-reaching consequence. My lord. For 2 minutes, my lord, in the district of Alipurduar, my lord, there are 2,954 bail bonds, which was the fake and fourth bail bond. My lord, in personating someone else's name, he was the surety. The present, my lord, the appellant. He stood as a surety. Now the question was that his initial capacity was 50,000. Long back, 15 years back. So, my lord, unless it is enhanced, my lord, so definitely he cannot stand for on behalf of 295 because it is a reducing, my lord. Then, my lord, a report was called for the London district judge, filed a report. Then only it was detected that the 2954 bail bonds were furnished. Then, my lord, there was a report from the London SCGM, even that report is there. Then it was sent to the postal document bureau, my lord. The signatures is not matching. Then, my lord, the accused, my lord, one of the lawyer, they are practicing there in Alipurduar. Then, my lord, he was arraigned as an accused and then obtained a bail from this honorable division bench. In this score, my lord, then already we are in the verge of the completion of the investigation, my lord. Then the coordinate bench of this honorable court, or it should be because there are certain difficulties, my lord, by the SP, because SP was the monitoring the investigation, SIT was formed to some extent to interrogate the, my lord, to the person concerned attached to the my lord, subordinate judiciary, my lord, because unless the peshkar or the bench clerk or the, my lord, the person concerned keeping the, my lord, the bail bonds registers, if it is not, they are not involved, it cannot be, my lord, perpetrated. So this is the reason when the case was handed over to this court to CID, my lord. And all these, my lord, the documents which was even the question document department and the others investigation which has been carried out handed over to the CID. CID has carried out. See the preliminary report, my lord, is a sealed cover with a copy to me, my lord. Kindly get to the this is not.
ওই যেখানে বললাম না, পঙ্কজকে বললাম না, তোমাকে বললাম। In the aforesaid facts and circumstances যে বললাম না, ওর আগে ঢোকাও, the learned additional advocate general appears and submit on behalf of the state that the investigation in connection with the allegations against the appellant has been handed over to the Criminal Investigation Department, Government of West Bengal. In short, CID. The CID has filed a preliminary report has furnished a preliminary report in sealed cover to the learned additional advocate general for being placed before the court.
For layover.
The report in sealed envelope is taken on record, but is not opened since the appellant is seeking an adjournment. Taরপরে in the aforesaid facts.
But any further progress report is required to be submitted from the CID then.
See, when the matter is taken up, the bench will open it, then it will.
And there is no direction from your lordship side.
See, we are simply adjourning.
Helpful.
He is right, নেক্সাস না থাকলে হবে না। ঠিক আছে, পরে
Item number 16 and ballot
কিছু নেই।
out of the what happened because I have already
এটা বন্ধ করে দাও তো, লাইভটা বন্ধ করে দাও।
I have stop by my
भैया आइटम नंबर 16
My lord.
चल रहा है ना?
My lord, I'm appearing for 16 for the respondents. The live streaming is paused.
আমি তো খাইনি ছেলে,
হ্যাঁ
কিচ্ছু
ছেলে
ছেলে
হুম
কি খেয়েছি বলে কেউ কিছু খাইনি। ডিমটা একটা মিষ্টি খাইছি।
খাইছিস?
Item number 16, 17, 18, and 19 are similar matters. These are appeals.
My lord, 16, I'm appearing for the respondent, my lord.
Yes, what is
There's only one question to be decided in this appeal is the payment of the statutory deposit in terms of section 112 of the GST Act. That has not been directed in the impugned order.
Yes, what do you say?
No, in fact, there is a division bench judgment of the. My lord, there is a division bench judgment of the Honorable Calcutta High Court by Honorable Chief Justice. That judgment holds the field, my lord. The appeal is not well founded.
But the judgment which my learned friend is referring to, that judgment is on specific facts where the GST authorities of the state as well as the GST authorities of the Union of India proceeded simultaneously against the petitioner concerned and issued tax invoice, issued letters. Now, in this case, my lord, is totally different. Facts are entirely different. Here, it was allowed by
No, there are not one. There are so many judgments. Let the matter be hard out.
thing remains is the provision under section 112, subsection 8 of the GST Act, that whether 20% is to be paid or not to be paid. That is the only thing to be decided in this appeal. But as per the provision of the statute,
thing that stands in the way
required to be made for the purpose of staying the recovery proceeding, the Honorable Court below has chosen to stay the recovery proceedings against the petitioner concerned. But for the purpose of staying the recovery proceeding, the 20% deposit of the claimed amount is to be made. That has not been done. That is the only.
So you
the only thing is, my lord, under 112. My lord, I'm appealing for the respondent. The 112, section 112 says they have to first establish a tribunal, and then only that payment comes into picture. So the judgment of the Honorable Court was you first issue the establish the tribunal, and thereafter there's a question of payment. That is the crux of the judgment, right from the main bedrock from where this thing flows below.
Oh,
they have not set it up the tribunal.
No,
Lochem India.
Previous circuit, I dealt with this. The president had been appointed, but no member, and the tribunal has not been set up.
Yes, true, my lord. Your lordship's order is also there in Kanchanjunga Oil
The
Mills.
petitioner sought preference.
Yes.
That he wants to appeal before the tribunal as when it is.
I cannot go before the tribunal unless it is constructed.
If the petitioner,
I cannot go before the tribunal unless it is constructed.
Very well. You come with the judgments tomorrow.
As your lordship.
My lord, day after. My lord, day after. My lord, day after.
Does not make it
Day after tomorrow. My lord.
Oh, he said that he was not. He will.
My lord.
In the previous matter, he said.
Yes.
After tomorrow.
Yes, my lord. Yes, my lord. Yes.
For another matter, my lord. Kindly. If my lord takes it up tomorrow, I'm there, my lord.
My lord, day after tomorrow or the next day, Friday. Any day, lordship pleases, excepting tomorrow. I have been making the consistent prayer.
See, your outstation versus his outstation. If you can do in the virtual mode tomorrow, no difficulty. Let it remain in the list if you can do in the virtual mode. You ask your junior to be there with the judgments.
My lord, I need to plead this matter, lordship. Kindly give me 1 day's time. 1 day's time. Friday, my lord, if lordship kindly takes it up on Friday.
He will not be available on Thursday.
I will.
Your other side counsel will not be available because since you are going before the Delhi High Court, you want
Friday, my lord, Friday. Not even on Friday.
বৃহস্পতি শুক্র থাকবো না, শনিবারে আসবো।
If you can do it through virtual tomorrow, no difficulty.
Next circuit করলে করে নিতে পারবো।
or whether you will.
My lord, I will try. I will try.
Your matter through virtual mode
the only
on Thursday.
The only difficulty is that I will be traveling entirely on Thursday. That is I have my matter on Friday, and I have to travel 12 hours tomorrow to reach to the court, and thereafter I'll be traveling back on Saturday. My case is on Friday. That is the problem. The entire day tomorrow, on Thursday, I would have to spend traveling. 12 hours it will take for traveling.
12 ঘন্টা গাড়ি চেলে কোথায় যাবে?
But I have to go to Samastipur in Bihar.
সমস্তিপুর?
Yes, sir.
Travel a train.
It is better to go by road because the roads are better compared to
Out Assam or something like that.
at the middle of the night, that is the timings are not proper. That is why we are going
district court. District court.
Yes, Mara. This is state. It's a state matter to defend the state.
If my learned friend could manage in.
I had the occasion to visit Samastipur district court.
It's a big court. It's 34 courts in total there. There are 7, 8 these subject courts.
Samastipur, then Hajipur, all I had to go.
The road is very nice now. It takes about 12 hours though, 10 to 12 hours.
Very well, let it be, or otherwise we will place it before the next circuit. Whatever.
That would be better.
My lord, I will try my level best. I will try my level best if it is possible, because tomorrow only I have the matter. Tomorrow only I will travel.
Very well.
My lord.
Not today করে রাখো, তারপর দেখছি।
Great.
17, 18, 19.
হ্যাঁ।
16, 17, 18, 19.
Item number 20.
My lord, great.
Item number
I'm only for 16, my lord. I'm only for 16. Great.
16 in other 17, 18, 19.
17, 18, 19, my lord, there was a direction from the previous bench to file affidavit to cause service upon the petitioner again. I have served again. I have the affidavit of service, but no one is available.
Very well. Let all the matters be there.
It is the same.
Oh.
Affidavit of service I have. I have already served as per direction.
Keep it to.
Grateful.
Yes.
Grateful.
Why? Let us get ourselves ready together. What is the matter about?
Order of Honorable Justice Krishna Rao. The
Yes.
bank account was freezed.
Yes.
The accused bank account was freezed, and there was certain directions from the state against that order. We have preferred an appeal. So,
What is it difficult? Get yourself ready tomorrow.
take some time.
We'll give you time. No difficult. Day after tomorrow.
Item number 21.
Two appeals, my lord, from the same order.
So, Mr. Thakkar, I told you in
In this matter, I am appealing for the WBSC DCL on the last.
My lord, I am appearing for WBSC led by Mr. Anirban. On last occasion, there was a direction to file an affidavit. My lord, that has been affirmed. Your lordship kindly allow my junior to file this.
You have got a copy of the affidavit?
Yes, well, they've given us a soft copy. This is the same hard copy also. So the same affidavit which they had given earlier in a notarized form, now they've got it affirmed here before the oath commissioner.
Yes.
Short, there are two appeals, my lord.
Would it be possible in 5 minutes?
My appeal will be, but I don't know about the state's appeal. State appeal challenges, my lord, the order of the learned single judge directing payment of incentive. But my appeal challenges the same order only to the limited extent that no interest has been granted for monies which are due and payable since 2012-13.
See, the first order, if I correctly remember, interest was there. But the second order, I do not find interest in your matter, probably.
No, not this matter, my lord. In this matter, there were two orders. First, my lord, when I came before the Honorable Writ Court, my writ was disposed of recording the facts, but giving an opportunity to the state respondent to pay my monies, and I was directed to make a representation.
Yes.
That was a order of my Lord Justice Datta. All the facts were succinctly recorded, but the state was given a limited time to consider the matter and dispose of with a reasoned order. When I went before the state and made my representation, they rejected it only on one ground, that you have not disclosed the money receipts of payment of the area bills in the revision. So you have
Yes.
the only one ground was there, my lord, taken by the state pursuant to the order of the Honorable Writ Court, that you have not disclosed the money receipts. And they said that disclosure of money receipts is mandatory under the scheme. There is no such provision in the scheme. Your Lordship will see it's a very simple scheme. There was no such provision, but on that flimsy ground, when the Honorable High Court had already recorded that the licensee is certifying that the payment has been made. Licensee certified before the Honorable High Court that the payment was made. Honorable High Court gave the state an opportunity that you do the needful. They again rejected my representation, saying you have not disclosed the money receipts. When in the prior round before the court court was satisfied that licensee has certified payment. So I came before the writ court a second time. Again, my lord, here again they took multiple grounds which were beyond the ground taken in the rejection. So that, my lord, is perhaps not permissible. The decision, the reasons given at the time of decision, they have to stand by those reasons. They cannot be supplemented. But they took various reasons, all of which were negated by the Honorable Writ Court, and they were directed to pay me the incentive, which was long overdue. But, my lord, the Honorable Writ Court did not pay me interest, did not grant payment of interest, which is the short ground in which I am before your lordship. They have assailed the order of the Honorable Single Judge, primarily on the ground that there is still no clarity as to whether payment was made by me or not. In the first round, my lord,
Who is appealing for this
they
stay?
never appear, my lord. They were there, but your lordship heard the entire matter, then they responded. Now, my lord, before the division bench, my lord, Honorable Division Bench in the earlier circuit, the licensee was directed to file a further affidavit again, that whether you have received the money or not. This is that affidavit. So 2 rounds, 2 circuits, my lord, have already
In that affidavit, we have already made it clear.
Thakkar,
Yes,
are you staying over? If you stay over, we can keep it as the first matter tomorrow.
My lord, I have certain fixed matters with the principal bench, my lord. That is the only difficulty. I had taken a day off. I'll stay, my lord. If your lordship kindly fix the time, my lord, then we will give them notice and come.
Today, as it is.
Yes, the court's time is over, my lord.
No, today as it is, you cannot go back by flight.
No, there's a 8 o'clock Darjeeling mail, I think. Flight is gone. So, but the state is not represented now. That is the difficulty. It is their appeal now.
You still travel by train?
Yes. Very convenient, my lord. You don't miss and your lordship knows that going into the airport 2 hours before you have to go do check-in, the same time, the conveyance time to the airport, if you calculate all that, the overnight train is much more comfortable.
Now, when does the Darjeeling will reach Jalpaiguri town in the morning?
Starts at 6:45
from town.
6:45.
State, yes. My lord, my learned friend appears for the state, my lord.
Mr. Bormon, so far as they are, see, the difficulty is that they are only asking for interest. But your challenge is an overall challenge to the order. Now, we cannot dispose of his appeal without hearing you. Come tomorrow, first matter, because Mr. Thakkar has agreed to stay over. Tomorrow, first matter, if you can, otherwise, no. Because
Problem is that we have received the reply of the department today.
not reply, the affidavit.
There is a 2-page.
See, the issue is, one issue is, we had heard this matter last day. One issue is that the receipts were evincing payment of the bills raised by the licensee on the industrial house has not been produced. Now see, 2 things. One, if there was default, then the electricity connection wouldn't have been there. Plain and simple, logically. You do not pay your bill for 2 months, you will find green bill and then.
It is 12 years now, man. These are areas of 12 years.
So that is logically, but since you have preferred an appeal, we have to hear you out. And because of your appeal, his appeal cannot be proceeded with. Because unless we hear out your contention, whether and decide upon whether the order has to be kept or order has to be rejected, we cannot decide his right in respect of interest.
This writ is pending since 2018, my lord, and your lordship, this is the third circuit bench which is taking up this matter.
Come back tomorrow morning.
This affidavit, my lord, was served on them on 22nd May.
First matter tomorrow.
Needful, my lord.
Yes, day after tomorrow, Mr. I cannot keep Mr. Thakkar. You can do it virtually.
There will be some difficulty, my lord. Kindly keep it tomorrow. So, very old matter, my lord. Appeal of writ of 2018.
Get yourself ready overnight. Nothing is there. In writ petition, appeal arising out of a
Affidavit आपने file कर
take down. Affidavit in opposition on behalf of respondent number 1 filed in court today is taken on record. A copy of this affidavit has been already served upon the upon the appellant appellant and the respondents. Appellant and the respondents. Appellants and the respondents. Full stop. The appellant in MAT number 73 of 2024 submits that their appeal is restricted only to the extent of interest payable on the principal sum. Where is the order impugned, Mr.
in my appeal. Decision with reasons is at page 238 of my paper book, my lord. The operative portion starts at 238.
Your paper book, there is no paper book.
There is, my lord. It is here. Prepared by Mr. Barikh's office. Starts at 224. Certified copy of the order starts at 224. Operative portion is at 238. Starts at 238, my lord, and at 240 is the order. At paragraph 16, subsidy of 2 crores 50 lakhs.
$238.
Yes, well, that is where the analysis starts at 238. The analysis starts at 238 and the direction, operative direction is at paragraph 16 at page 240. The judgment is of February 22, 2019.
কি বললাম?
The appellant in MAT 72 submit that their appeal is restricted only to the extent of interest payable on the principal sum
of rupees 2,50,37,115, which was directed to be paid to the appellants under the West Bengal Incentive Scheme of 2007. but without interest. Full stop. The appeal against the same order dated, same judgment and order dated 22nd February 2019, filed by the state being MAT
States committee is.
Our one is 1 of 2020.
yes, one,
1 of 2020.
being MAT 1 of 2020 is however an order, is however, না কি বললাম তোমাকে?
The appeal against the same judgment and order dated 22nd February 2019, filed by the state being MAT 1 of 2020.
Is however in connection with the entirety of the order. Full stop. It is therefore not possible to pass effective order in the effective order in MAT 73 of 2019 to 2021.
24. After renumbering, it was transferred from the principal bench to this bench.
24 without hearing the MAT 1 of 2020. Full stop. Let the two appeals retain his position in the list and shall be taken up on taken up tomorrow on such and such. কোনটা আর একটা কোথায়?
Yeah, these are two matters.
With the order.
না
Well, have been pleased to indicate that this will be the first matter tomorrow.
retain its position. এটাকে এক নম্বর মামলা করে দেবে।
Deeply obliged.
এইটাকে এক নম্বর করবে।
ক্রিমিনাল গুলো পড়ি নাকি?
হ্যাঁ
ক্রিমিনাল গুলো পড়ি। অ্যাপ্লিকেশন অফ অ্যাপিল ফ্যাপিল আছে।
ক্রিমিনালের যদি কিছু আসে সেগুলো আগে দিয়ে দেবে, ঠিক আছে?
বেল আছে, বেল ফেল আছে।
সাসপেনশন অফ সেন্টেন্স, ওই অ্যাডমিশন আর সাসপেনশন অফ সেন্টেন্স থাকলে ওটা দেবে, তারপরে এটা দেবে।
Deeply obliged.